All right, we're going to go ahead and get started, but we're excited y'all are here. We do have a few changes or a few modifications rather, to the schedule, because we do have some speakers that are iced in. So exciting. In Atlanta and some other places. Bob Redding is going to be our first presentation in just a few moments. And he knew that he was not going to be able to come, but we also felt like the information he was bringing was important. So you will see a video from him, and then we'll have a Zoomed speaker, and then the rest should be here. So just giving you a heads up. I guess it's mitigation. There we go. But welcome to Business Operations. I'm Beth Olson. I'm actually Director of Education for the Georgia Fruit and Vegetable Growers Association. I'm going to be moderating for the first little bit, and then Chris Butts, who is our Executive Vice President, he's currently running the awards breakfast next door. He'll come in and he'll finish things up for us. So without further ado, we're going to, again, this is a video from Bob Redding, and Bob Redding is the president of the Redding firm. He is the lobbyist for the Georgia Fruit and Vegetable Growers Association, as well as several other organizations around the Southeast and the United States. But he's really going to be giving us, as far as he can tell, the political outlook for 2025. As we all know, there's a new administration. The winds of change seem like they're going to be starting up very, very soon. Actually, already have. So you'll see Chris Butts first, kind of giving a little bit of an introduction, and then we'll have Bob Redding come in. Please let me know if y'all can't hear in the back, okay?
Hey, good morning, Bob. We're recording this on the morning of Friday, January 3rd. The election cycle has certainly shuffled the cards in Washington, D.C., and today we'd like to talk about these changes and how they may impact fruit and vegetable producers, but more importantly, how they may impact the work that we've been doing together in Washington, D.C. So let's just jump right in. As December unfolded and we were looking at a possible government shutdown, there was a lot of activity around disaster funding, but also around economic assistance funding. Where did we land on disaster funding?
Well, good morning, Chris, and it's good to be with you. I wish I could be there in person. Ad hoc disaster legislation is hard. It's just hard. You're hanging out there. It's a lot of money, and you typically have a short window of time to get it moved through Congress and signed by the president. It's hard to get with a limited amount of language in appropriation bills. And for the last number of years, we've had to do them through the appropriations process. So it's not like a farm bill where we can address page after page of what this ad hoc assistance should look like. We don't have that opportunity. And that's good and bad. And I'll sort of explain that in just a second. After Hurricane Michael, there were some holes in the process that had to be addressed. Some of these were addressed in subsequent legislation and some by administrative action at USDA. When we brought down, you were down there and helped host the Risk Management Agency administrator and her team from Kansas City and Valdosta to go through the specialty crop areas and look at the damage done to commodities and also some of the holes in the crop insurance process, particularly for vegetables, and some for blueberry, some for pecan, but not at the level we've seen with regard to vegetables and the damage that they typically hit and lack of crop insurance opportunities. Those holes you want to try and get as best possible fixed on the front end, and having the administrator down looking and listening to growers about opportunities and lack of opportunities for vegetable growers and others. That was really an important visit, because as we move forward, even though the administrator is a political appointee and in theory moves out after January 20th, the staff attendees, senior staff, are career RMA employees, and for them to gather information and data about losses and needs and lack of opportunity, particularly in vegetable space, that was really important. That's just one of the holes. Continuing resolution we passed right before the holidays had $21 billion in ad hoc ag assistance. The president proposed, I believe, around $24 billion. $21 billion is a lot of money for ad hoc assistance, and hopefully will be sufficient. As I mentioned earlier about the brevity of language in these appropriations bills, the number one priority for the Southeast, and particularly for Georgia, had to do with block grants to state departments of agriculture, which we got that language in there. So at the end of the day, that was number one. Well, actually, number two. Number one, get the money, and number two, get the block grant opportunity for Commissioner Harper's team and others to work on assisting these growers that have been hit so hard. The block grant language, as I mentioned, is important. We found out through Hurricane Michael, and even before in Florida with citrus and a previous hurricane, that these block grants to state departments of ag for specialty crops, unlike row crop, don't have the historical processes at Farm Service Agency to get fixed.
Yep.
And state DOAs can work with stakeholders. They're on the ground. Meetings are easier. You're not flying to Washington. You're meeting with your state capital or your county or state committees. And we can get these issues resolved a lot quicker. You also have more institutional knowledge with the State Department of Ag staff versus what FSA might have been through over the years with specialty crops. We went through a lot with that. We were very fortunate at the time to have a state director who worked well with the Georgia State Department of Agriculture in trying to make sure USDA in Washington understood that there were plastic issues, irrigation issues, cleanup issues, greenhouse issues. And on the tree nut side, with regard to pecan, we're seeing in this time around, you have a tree loss, you have production loss, but you also have future income losses. The same with citrus in Florida the year before Michael. So all of those are areas where your state DOA is going to be in a position to help more. Now, one of the things that, just an aside here for blueberry and pecan particularly, the tree assistance program is antiquated. We updated a little bit after Michael, but unfortunately, the tree assistance program, like some of the other items and some of the other opportunities for specialty crops and crop insurance, the Farm Bill hasn't passed yet. So a lot of the reforms we have, we want in place that weren't in place in the 2018 bill, we're stuck. We're still in the 2018 bill environment or structure. So once we get this new Farm Bill done, they will address a number of these items, like particularly with TAP, that we wish were addressed now. They'll either have to be done administratively or we'll have to go back in on things like mortality rate. Georgia has a very high mortality rate. We had to go in legislatively and reduce by half the mortality rate, for example, after Michael. Those are the kind of things that we'll have to take care of at some point that the ad hoc assistance will not include in this language.
Well, to your point, I think we all learned a lot of valuable lessons after Hurricane Michael, and we can learn from those and put those to work in this case. We've already been in touch with Commissioner Harper's office, and we're engaged with them, and we'll work with them to roll this out as quickly as we can and get that much-needed disaster funding into the hands of people that are hurting. Earlier in December, leading up to that, there was a new program announced by USDA, the Marketing Assistance for Specialty Crops Program. That was funded initially with $2 billion. And that application period actually ends January 8th. So I believe we'll be presenting this on the 7th. So the day after we show this video, our growers need to have those applications completed. Where do we think we'll end up? Is $2 billion sufficient for that program, or will it possibly need, and could it get other funding going forward?
Well, you make some really good points, particularly emphasis on that application deadline of January 8th. It's tight, and we need to get it in. Growers need to get their apps in. We don't want to be confused with this market assistance specialty crop program and the economic assistance that was put in the continuing resolution. This market assistance for specialty crops is a CFAP 2 type program for those growers that participate as a sales commodity in 2021 with CFAP 2. This is very similar. The Secretary moved $2 billion over, I believe, out of the Commodity Credit Corporation for this program. In looking back at the 21 CFAP 2 program, it cost approximately $3 billion for the sales commodity piece. And remember then, it was much bigger than specialty crops in 21. But for the USDA announced program earlier this year, it's $2 billion. So we don't know why that number. We're sure for certain USDA for sure came up with some analytics that pushed them towards the $2 billion. We've been a little concerned about it because it is short of what was spent in 21. But during the negotiations of the continuing resolution, several members in the House, particularly in the House, and one in the Senate, brought up, could it be short? What are we going to do if it is short? House committee staff, as well as some members, key ag members of Congress, were clear that they would work with USDA if it's short, and we don't know that yet, to move additional funds over to finish this out. So we'll watch it closely. We need to get January 8th behind us so the department can see what's out there. And, if it's a $100 application and the grower really only qualified for $80, what is the total, and is $2 billion sufficient? So we'll be working with Congress and USDA on that piece. But I think that's a really important question. And we don't want to do these programs and you do your formula and you qualify for $100 and Congress can only give you 30. And we've had that happen before on disaster programs where growers would qualify for several $100,000 and end up with, much less than that. So we'll watch that closely. This is important. When USDA jumped ahead with this program, with the MASC program, that's good. And also, we don't know yet with your question if it's bad. It's good in that the row crop piece, which passed the $10 billion, might not have made it. It was certainly in jeopardy, certainly in question, and we weren't sure until that final night, that it was going to move and go all the way. So row crops could have been left out. But by USDA moving forward, a lot of members, particularly in leadership, said, well, the specialty crop piece is already done by USDA on economic assistance. So it was a guaranteed program, which we were not guaranteed anything with this ad hoc type economic assistance. So that was good that it got in early. Hopefully it'll be enough. If it's not, we'll get back in there and try and get some more.
Great. Okay. Well, let's shift gears a little bit. Not news to anyone, but we've got a new presidential administration coming in, Trump 2.0, so to speak. And there's a lot of talk about tariffs, mass deportations, and other initiatives that could impact the industry. What do we know about these, and how should we be preparing for the possibilities of these presidential actions?
Well, I think we need to probably stop the hand-wringing. And we're here in a couple of weeks. We're going to have a new administration, new president, president who we've seen before, who we know supports production agriculture, a president and administration who could not have been more aggressive, successful on some initiatives in agriculture, not successful on others. But they made a good faith effort on trade and USDA type programs. And also, to a degree, on the Department of Labor Ag Employer initiatives. Did we get everything we wanted in production ag? No. Did we get a lot? Yes. So it's never going to be 100%, but we're hopeful, particularly in the ag space, that the H-2A will move forward with reform, and the administration will do what they can administratively. And we will also see them work closely with the Republican House and Republican Senate for true H-2A reform after these initial reconciliation packages that move forward, whether administratively on the border or in with Congress's action, which will come first before any H-2A reform. A quick note here on the other choices down the chain. I think the real win for the Southeast, the real win for Georgia specialty crop production ag, is the nominee for U.S. Trade Rep, Jamison Greer. He was top staffer for Bob Lighthizer, Ambassador Bob Lighthizer, when he was U.S. Trade Rep in the first Trump administration. He worked on the blueberry case for blueberries and at the International Trade Commission. And although the case was not successful, we had a change in administrations right in the middle of the case, which was not good for moving forward with the blueberry issue. But he knows this issue, and we won't have the educational piece. As you know, you're a member of the Seasonal Import Federal Advisory Committee at USTR, and how slow that's been to not only get people in place, but to even meet.
Yep.
And how frustrating that's been not to even have an educational body, stakeholder body in place to work with an administration. It's taken forever. Well, now they're gone. It's over, and we're starting all over again. We won't have to start all over again with Jamison Greer and his team. They already know this issue. Now, hopefully, we'll find some type of solution for it. We also have members in the House and Senate that are very interested in the seasonal import issue, and we're hopeful that when we talk about the Congress, that will be something that moves forward too. At USDA, we've struggled with the NASS analyses. We've tried to work with NASS on it, finding a solution for it. There are multiple issues with it. There are issues on the industry side. There are issues on the administrative side. So working with Congressman Bishop and Austin Scott, other members in the Senate from the Southeast, that we can get to a better place there. And with the U.S. Department of Labor that will be more receptive to the ag employer side. We've not had that situation with this administration. As you know, we've taken these multiple AWR hits, I think about 3 in a row, which have been killers for our guys, whose only option has been go to the courts, which is expensive, time-consuming, and getting money back is almost impossible.
Yep.
So we're hoping that won't happen. On one other piece here on the U.S. Department of Labor, even though they might argue they've had stakeholder input, this administration, the current administration, has turned out these H-2A ag employer administrative mandates that are killers. And once it's out there proposed, turning it back's hard. You want to have a relationship where you're dialoguing about it, and it's not happening at the levels we've seen in the past. So we're hopeful that we'll have more input on the ag employer side at labor before these things are pushed out in the marketplace and we're on defense.
Well, and certainly, we've had our initial win in court with DOL's new worker protection standards, and that kind of paved the path for success in some of the other suits. We're hopeful that may clear a path for some of the suits that were filed pre-Chevron that could use some of our case law as precedent, but we'll see. So let's shift. We've also got new leadership in the House and Senate. I think we've got a vote for Speaker Johnson today. How do we see the House and Senate changes affecting us?
Well, we have a really good pro-ag team in Congress right now. It is, I will tell you, G.T. Thompson's done a good job. He got a bill out of committee. It is a production ag friendly bill. Does it have everything we want in it? No. Does it have a strong production ag message? Does it have a lot in there for specialty crop growers and others? Absolutely. So we want to see these bills move forward. Chairman Thompson will remain in place. We have a new ranking member with Angie Craig of Minnesota, replace David Scott. we have been, as Southeast growers in Georgia, have been strong supporters of David Scott. Hated to see him not continue in that role, but Angie Craig will do a good job and work well with the new ranking member, Amy Klobuchar from Minnesota in the Senate. On the House Judiciary side, Jim Jordan will again chair. We have a new ranking member, Congressman Raskin from Baltimore will become the ranking member after today. And so we are hoping that we'll see movement at some point early this year in the ag reform space. We know there are issues that are going to move forward before H-2A reform, but we'll talk about in a second, some of the options there, more specific options. But we're hoping with members that have been assigned to the committee that we'll have some strong advocates on there for agriculture. One thing you mentioned about the speaker's race, Mike Johnson from Louisiana is very pro-ag. He gets the H-2A program. He gets the need for fair trade, balanced trade, not just one-sided. And he is going to continue to be friendly to packages that come out of these committees, whether it's a farm bill or whether it's H-2A ag reform coming out of judiciary. He's a member of the Judiciary Committee, not an active member now as Speaker. He's a member of the committee. And I can tell you, accessible, open. He's been all over South Georgia. He's hunted in South Georgia with his boys. So he gets it. He understands our culture and agriculture in the Southeast and the specialty crop space. And he has some specialty crops in his district. So he is definitely the guy you want to remain as Speaker. President supports President Trump, and all of our key people are behind Mike continuing in that role. So hopefully that'll work out. In the Senate, we had a strong specialty crop advocate with Debbie Stabenow from Michigan. She's gone. She certainly should be credited for putting in place specialty crop block grants, specialty crop research initiative, programs that the Southeast associations participated in and growers have benefited from. But there are other issues there that also weighed that down, payment limits and these kind of things that does not mirror what the Southern production ag culture is. These farms are big. It's tough to have a 10-acre specialty crop farm. It's hard, and to have the infrastructure to market your products. So as these farms are increasing in size, and particularly with the farm economy we've had, you can Google it, you can drive through the countryside in the Southeast, auction after auction, farm sale after farm sale, it's happening. And they're not selling it because it's fun. They're selling out by necessity and to keep going. And some maybe not keep going, but for many, it's to keep going another year, but with a smaller operation. So having Klobuchar coming in as ranking, she gets it. She's from Minnesota, not a big specialty crop state, but a big production ag state. Her farms are big. She's got big sugar, dairy, hogs, corn, wheat, soy. Her farms are big. They're not a lot of mom and pop operations. So she does understand it. When she first came to Congress, then Chairman Colin Peterson of Minnesota worked with her. He is, as you know, has been into vegetable farms in the Southeast. He's toured them, rode around with our farmers in the Southeast. He gets it. He understands it from Florida to Georgia to North Carolina. And he's done a good job, I think, of expressing to her that we've got to have all of these regions healthy financially, economically, moving forward. It can't just be the Midwest versus the Southeast, or in our case, California versus the Southeast. That won't work. It does not work. Southern passes in the House for the West, Senate, Southerners kill it. That and vice versa. It's just not healthy. The new chairman of the committee in the Senate, Chairman Bozeman's rock solid, balanced approach. He has heavy grains, cotton, and rice state, not a lot on specialty crops. He's got a good many pecans in his state. But he is really a fair man and will be an advocate for all of agriculture. I look for him to have a lot of specialty crop provisions that will be similar to the House, but open to other members. And he's a bipartisan guy and really a good man and will be really do a good job. So I'm just glad he's there, and we will see some, I think, very positive activity moving forward from his team. He has a really strong staff who gets the Southeast, and they get specialty crop. We had two changes that have happened this week relative to Georgia Senate. Senator Warnock is now on the Finance Committee. He's still on Ag, but on the Finance Committee. But the Finance Committee in the Senate is responsible for all trade. So import, export will be important, and we'll look forward to his subcommittee assignments. Hopefully he'll get on the trade subcommittee. Don't know all that yet. But Senator Warnock being on that committee will be very helpful for Southeastern agriculture. Senator Ossoff has left Judiciary, which handles our immigration issues and H-2A issues, but he's a new member of Appropriations, which, as we saw with this recent disaster package, it would have meant even more having him there during that disaster negotiations. So having him move to the Appropriations Committee is really positive for Southeastern agriculture.
We certainly enjoyed. We met with Chairman Bozeman twice in 2024, also in 2023, and I agree. He understands our culture and our issues, so we're looking forward to working with him. Along those same lines, we've got another Farm Bill extension now. How does that play for specialty crop growers on issues like trade and imports?
Well, we will. The House bill will be reintroduced. There could be some changes. I don't think there'll be radical in it. We're certainly hopeful it will be included in the House bill. The Senate bill, we did not have text from now Chairman Bozeman as ranking member. He sent out like a summary. They know this issue. As you know, we've met with him on this issue. We're hopeful. We know Senator Warnock and Ossoff have been supportive. Senator Warnock has increased his seniority on the committee as on the Senate Ag Committee, and we're hopeful it will be included in the Farm Bill process, if not through the appropriations process. But it's important that we not ignore an issue that is unique to specialty crops on the import side. It was important enough that then President Trump and Ambassador Lighthizer made it a priority during the USMCA negotiations. And it was on the table from the U.S. side. Mexico and later Canada became problematic in the final agreement, and we did not get in. But the administration, the previous Trump administration, could not have done more to have helped us in this process. First in USMCA effort, and then at the ITC until their last days in office. So we're hoping that now that we have a seasonal import team friendly in place with our current team in the Senate and House, that we'll see some progress on this.
Last thing I want to ask you about is labor, and we talk about this all the time, and frankly, as an industry, we've been talking about it for 25 years, some ag labor reform. As we mentioned, we're gaining some traction through the courts, but we're hopeful this administration could be the one to get something done on ag labor. We've got a framework in the document that came out of the House Ag Committee last year, or last summer. Is that framework a possible mechanism to finally get some ag reform done?
Absolutely, and that is the template. And it doesn't mean it has to be exactly like that in the final product, but that's the bill, the structure of a bill, the template for a bill coming out of going into the House, this new 119th Congress, that we should certainly support. I talked to Chairman Thompson right before the holidays. He was very clear he'd like to see it move forward. They presented it already to Chairman Jordan at House Judiciary, which has jurisdiction. But having Chairman Thompson, Rick Crawford as chairman of the working group on ag labor, his Democratic co-chair, Don Davis, who's got specialty crops in North Carolina, leading that effort, that bipartisan effort will be critically important. We've got Austin Scott, who's vice chairman of the committee and could not have been more helpful over the years on H-2A reform. and ag employer issues. But the industry has to do its part too. And as we've discussed at the Southeast Ag Labor Forum, which Georgia Fruit and Vegetable hosts each year, this has been a constant issue that's been brought up. We got a lot of ag employer organizations advocating for various priorities. Even though they can get together on a bill, their priorities within that bill certainly run the gamut, and it's failed. It killed us in the 118th Congress in moving forward, and we had several opportunities to get something. So this will be one more opportunity going into the 119th for agriculture to put aside egos, to put aside being their bill, that it be a regional bill, it be a Western bill or a Southeast bill or whatever, that let these members who know what we need, there's no question about members being educated about H-2A ag labor reform, what's been done to ag employers via the AWR changes in the last 3 years or so. This is an opportunity for all of production agriculture, because row crop is needing this stuff too. Cotton already uses a lot, some others do, but they're getting right where specialty crop is, with a limited workforce, a very administratively burdened processes for H-2A. The row crop is on top of us now. They want to use H-2A in many cases. That's going to increase, and it's peppered throughout that working group report and the hearing they had, or the meetings they've had. So for our purposes, we need to let Chairman Thompson and his team work with Jim Jordan in the House and come up with a package, and that it be a bipartisan package that all of ag gets behind. And we're going to have these 6 other bills out here with 12 amendments coming along the way. It's not a wish list. This is not Christmas morning. This is about trying to get it done. As you know, many people have come and gone, made their careers off running an ag labor issue, ag employer issue. And this is a time, I think, we let members take the ball and go with it.
I believe it was Ronald Reagan that said it's amazing what you accomplish if you're not too concerned about who gets the credit. So maybe that's our theme for ag labor reform in 2025. So,
yes.
Yep. Well, Bob, thank you. We appreciate you taking the time to do this. We appreciate all that you do for GFVGA and our members in Washington, D.C. And we'll be up there several times in February and March. So we look forward to continuing to advocate for our folks. So thank you for all you do, and we'll see you soon.
Thank you, Chris.
All right.
Bye-bye.
Thank you, ma'am. Bob Redding wanted us to send his apologies. Bob's father-in-law passed away this week, and he's been in Moultrie for that service. That's why he's not with us. And then the weather the last few days certainly hadn't helped anybody. 2 of our speakers today, Braden Buchek from Southeast Legal is going to join us by Zoom. Have you already announced all this?
A little bit.
Okay. Braden will join us by Zoom. Gopi Munasamy, who's with UGA, who's done a lot of work for us on research on imports, is not going to be along with us. But I believe Ann Margaret Pointer and Leon Segura can help fill that void and talk more about the bevy of litigation that's happening around the country on H-2A. A couple of updates since we recorded that video. Obviously, Speaker Johnson was elected to serve as Speaker of the House that day. Got through, I believe, on the 2nd vote, maybe the 3rd. We talked about disaster funding. A couple of things. On the marketing assistance for specialty crops program, that came out of USDA just prior to the CR being passed that included the disaster funding and the economic aid funding. So that's just for us, for our specialty crop growers. It was initially funded at $2 billion and had a $125,000 payment limit per entity. Since we recorded this, they have actually added $650 million additional dollars to the program and raised that payment limit from $125,000 to $900,000 per entity. The final amount that everybody will receive is ultimately will be decided once they figure out how many applications they have and they apply the formulas across there. But we were really, really pleased to see that payment limit increased. And if the program should perhaps be overfunded even at that, with that additional $650 million, I think we've had some indications from some leaders in the House and the Senate that they would be willing to certainly look at appropriating more for that program. So good thing there. On the disaster funding, We were speaking with Commissioner Harper yesterday. They have not been told a number yet from Congress in terms of what Georgia's share of that $21 billion that was approved nationwide for disaster funding. But he is ramping up his system. If you remember in Hurricane Michael, that money was distributed through the block grant program, and we were very fortunate to have language included this time. So this disaster money, no, I'm mixing those two up, aren't I, Lorraine? The marketing assistance money is coming directly to you. The disaster money for Georgia, for specialty crop growers and row crop growers, will also be done via block grants. Commissioner Harper is ready to roll that out as soon as he's got that number. All the commodity organizations, Georgia Farm Bureau, GFVGA, we're already in contact with his office, and as soon as they get that system up and rolling, we'll be able to share that information with you guys so that you can get those applications in. The marketing assistance program, we're very hopeful that you'll see payment from that in the first quarter. So sorry to confuse those two issues. Beth, do we have Braden? No. Okay. How about we switch gears? Can we do Ann Margaret next, and then we'll try to find out where our Southeastern Legal Foundation is, okay? While we're transitioning, and thank you all for your patience with weather and everything else, as I mentioned, we've got a bevy of lawsuits across the country involving H-2A. Perhaps most notable for us is the Georgia lawsuit that provided an injunction for the new worker protection standard rules from DOL. That injunction initially took place in Georgia, 17 states, and included two other parties. If you were the Miles Berry Farm in Georgia, who was one of the co-signers on that, they were protected, but also if you were a GFVGA member, you were protected from the implementation of those new rules. Other states, 33 other states across the country, didn't enjoy that protection. So lots and lots going on in that space, and Ann Margaret has been involved in a lot of it. She was recognized this morning at our awards breakfast for her work in this with the Dan Brimmer Service Award for ag labor. So we are thrilled to have Ann Margaret with us. Thank you all for being flexible. We'll kind of shuffle around here and see if we can find Braden. Okay. I'll turn it over to Ann Margaret.
Leon, come on up, Leon. I had the happy circumstance of finding out this week that Leon Sequeira, to whom I will introduce you all. Yes, ma'am. Is there anything else I should be doing?
You've been handled.
All right. Leon Sequeira and I don't practice law together on a regular basis, but we sometimes do. I got to know him some years ago. He may have still been the chief counsel for Senator McConnell, Mitch McConnell, at that time, but then I really got to know him when he was the Assistant Secretary of Labor. Now, I didn't love everything about the 2008 H-2A regulations, of which he was a primary architect. But at my age, I understand that sometimes politics is what you can get, not necessarily what you want. And as a tribute to him, when the next administration came in and Hilda Solis was sworn in that very afternoon, right? She tried to rip out those 2008 regulations. I mean, she said, they're dead. We're going back to the way we had it before. People we both worked for, and he took a lead on this, disputed whether or not using the process of just saying the new Secretary of Labor said, I don't like it, I'm ripping it out. They said you can't do that. You got to use the processes of the Administrative Procedure Act. And that finally got sorted out so that those 2008 regulations that gave you some relief stayed in effect until the new administration came in, and worser, if you will, H-2A regs were put in. Well, so sometimes Leon and I collaborate on cases, always a pleasure. I found out he was in town, and since he is the architect of one of the injunction cases we're going to talk about today, I said, why don't you come and tell them yourself? And I'd love it if the folks who did the Georgia Fruit and Vegetable Association litigation here in Georgia with the 17 states plus Georgia Fruit and Vegetable Association and Miles Berry were here to tell you first what they accomplished and how they did it, because I don't want to steal their thunder. I want to be respectful of the results brought by these states. But Georgia Legal Foundation to handle the litigation, that they did a fine job and really, I would say, got the best injunction in the country for the entities within the 17 states covered, and Georgia Fruit and Vegetable Association members and Miles Berry Farm, because it stopped all of the provisions of the 2024 regulations that otherwise were going to go into effect June 28 this year. So that was an accomplishment. Leon, let's try to share this microphone, and please let's make this as collaborative as possible. Our discussions are not legal advice. We're not in a confidential relationship. They're not privileged, but we will talk to you about what these things are. All right, so things, why don't you come over here on this side and I'll try to share it with you.
I've got you another mic.
Oh, even better. All right, so what has changed in this legal landscape? One of the problems when a farmer starts talking about having to file a lawsuit to stay in business, you already know things are not good, because money that you spend in a lawsuit, generally speaking, you cannot get back. Plus, it requires a lot of time and attention. And I have to give this association real credit. Even if you do not see its name on some of this litigation, as I told Chris this morning, he's been a real bulldog, this organization, and he personally, in pursuing, trying to make possible changes into this program to make it workable. And we all understand it's not just that it's expensive, it's that you're facing costs from other directions, including the ability to market your commodities at a price you can afford to produce them. And let me tell you, somebody else said he'd been a fourth generation farmer. My family's been in farming since literally year one. I'm really the first person in my family, but probably both sides, but certainly on my father's side, not to make a major part of my income from farming. And I don't see it happening again. Now, of course, we were tobacco growers, and we were probably a good thing that I'm out of that business. But we're also dairymen. And if you know anything about the price of milk and cost of dairy operations and the cost of running a dairy operation, you're talking about some serious money here. So I'd say, even though we've made some headway in keeping the creep from moving forward in some instances this year, you still got to take a real sharp pencil or a good computer program and figure out what you can expect to produce and sell at a price that you can afford to operate, knowing that under kind of all the king's horses and all the king's men, we can only prevent some of the cost of complying with this H-2A program from falling on your shoulders. Now, starting at the litigation that has affected how we've litigated cases this year, there was a extraordinarily important case in which the Supreme Court said, we are no longer going to defer essentially to whatever the agency says is the interpretation of the law when the agency comes forward with a new pronouncement of how the law ought to be applied. And that would be in some of these agency regulations. We're going to take a fresh look. Now, exactly what that means in actual practice is yet to be determined, because at some level, the judges are inclined to say, this agency has all these people who know about this law and about the prior practice and what the effects are on both the people who want more regulation and the people who want less. And so we're going to give the agency the benefit of the doubt. Leon, you care to say anything about the Loper case? I think it's been helpful. I think you would say it's been helpful in terms of the way the judge looked at your case, but I also think you were smart about where you filed that lawsuit. And sometimes that makes a real difference in who you draw as your judge.
Yeah, I would just say, well, let me first say that I appreciate Ann Margaret the opportunity to be up here and pinch hit with you. Ann Margaret, as you all probably know, is a giant in this field. She's probably forgotten more about H2A than I will ever know. So I've worked with Ann Margaret on a number of cases over the years, and it's always a pleasure. So
a mutual pleasure for sure.
Yeah, I would say this really is an important case. You don't hear a lot about generally in the media. They talk about more probably politically divisive issues and abortion cases and things like that. But for administrative law, this case is a real change in the way that courts from here going forward are going to interpret regulatory action by agencies. And our judge mentioned it in our decision. You're starting to see it show up in more cases around the country. And I don't think we've yet fully seen the development of how this is going to change the way courts view agency actions. In shorthand, for 40 years, nearly 30 years, I guess, courts generally deferred to whatever the agency said. And this decision by the Supreme Court said agencies don't get any more say than anybody else. Courts decide what the law is, and the agency can put forth their view, but it doesn't hold any more weight than the plaintiffs or whoever's challenging their action. So.
Yeah. But I don't remember exactly what the count was on the Loper case, whether it was 9-zip, I don't think it was. You still got federal district judges around the country who are chomping for saying agency knows more than I do, and it's real hard to focus the judge on, well, let's go back to what the words in the statute say and what the Congress that was enacting this law said it meant to do. So, but this is a prelude to some of these cases that we're going to talk about that we won. Did I go through 2 slides, or was that just one? Yep, no. This is another case. Supreme Court also said, in actually a Securities and Exchange Commission case, where the basis of the claim is really like common law claim, that somebody contractually failed to do what he was supposed to do, you get a jury. You don't have to have a administrative judge hired by the agency that's the regulator making all the decisions about whether or not you complied with the law. And so at this point, we are hopeful. I have filed some appeals lately saying, with respect to the U.S. Department of Labor enforcement actions on H-2A programs of finding violations, finding failure to pay wages, which is underlying a contractual action. You just can't turn this over to a federal U.S. Department of Labor employee. You know, you heard years ago about the ALJs that didn't rule the way the people in charge of that agency at that time wanted, getting bad parking places. Now, I don't know if that was true, but you know, you gotta wonder, as it were, when you combine the prior mental perspective of the judge that whatever the agency says is probably okay, that got overruled when the Chevron case got overruled, combined with you've turned over all of the decision-making about the facts and how to apply the law to one individual who works for the agency. You got to wonder about that. Now, a bad problem, the Sun Valley case that you see there, referenced in the Third Circuit, the farm was a farm in southern New Jersey that employed, I think, about 19 H-2A workers. And without getting into all of the facts, there's a dispute about whether they were fired or left on their own. The employer had said in the job order that the workers were going to get free and convenient kitchen facilities to cook their own meals. You know, that's typically a part of one of the options for providing meals to your H-2A workers and U.S. workers who can't commute back and forth to their permanent homes. But instead, what the farm did was charged a flat $70 or $80 a week for food that was not disclosed in the job order. The supervisor at the farm sold drinks at his profit. And the farmer hit with over $300,000 in back wage claims and over $200,000 in civil money penalties, said you can't do that and have this adjudicated by a Department of Labor ALJ. Well, the Third Circuit, which is based in Philadelphia, said, oh, yes, they can. I don't think there was even a dissent in that three-person ruling that, at least for purposes of enforcing those wage claims that came about out of the H-2A program, that they would allow the agency's own administrative law judge to pursue the case. So did you follow that case? Was that something you looked at?
Yes, and actually I've got 2 cases pending in federal court now where we're asking for a jury trial as a result of the Jarkissi decision, which, you know, the Loper-Bright decision is sort of esoteric about how are you going to interpret what an agency does. This case, which virtually no one has heard of, I think is going to have more day-to-day impact, or at least has the potential
Where
to have more.
Where are your cases pending? What federal courts?
Have one in Eastern District of Louisiana and Western District of Kentucky.
Okay.
Where we asked the ALJ for a jury trial, and they said, well, I can't give you a jury trial. We're going to go ahead with this administrative proceeding. Okay. And we said, oh, okay, fine. We're going to go get a real judge and see what they have to say about this. Yeah. And so we haven't been granted a jury trial yet, but we'll know hopefully soon.
I'm smiling because those are probably both better places I'd like to be rather than in the Federal District Court for New Jersey and the Appellate Court for Philadelphia. Yeah. So, okay. Well, and what can happen then, if you're successful ultimately going up to the Fifth Circuit, good circuit to be in, or the Sixth Circuit, then that gets possibly to a so-called circuit split, so that the Supreme Court might take the case. And then that would just be, you know, a fabulous result if at the end of the day we'd be able to say, you just can't do it that way. And I'll just point out one thing more for these, you know, I don't sneeze at hiring 19 H-2A workers. That's not a big farm. And over $500,000 in liability is still a lot of money.
Yeah, and that's the problem with a lot of these cases. Anytime you're challenged in the Department of Labor, is it becomes a issue of money. How much money do you want to throw at this problem? The one case I have, they're trying to get close to $1 million out of the farm. That, you know, is enough that you're willing to spend some money on lawyers to fight in federal court. If they want $1,500 or $2,000 or even $10,000 or $15,000, even $50,000, yeah. It's a lot tougher question about how much time and money you're going to spend on lawyers to fight that, because in the end you're still out $50,000 or more. So.
Right. And then another case that's important We've run into this sometimes ourselves. There are issues in a regulation that we wanted to challenge, finally had enough effect for farmers to say we just can't live with that and this new regulation. If the rule used to be, if you did not challenge a federal regulation within 6 years of its issuance, you were just dead. You could not then ask a federal judge to look at it and say, this is not authorized under statute. And so this new case, the Corner Post case, said, well, the 6-year statute of limitations applies with respect to from the first day your plaintiff is affected. So if somebody newly comes into the H-2A program, then that person, if he's adversely or his company is adversely affected by even an old regulation, can go after it. And I think that's also a useful way to present some issues to the judge, federal judges.
Yep.
One other good thing about that is that, well, going on, another issue would be the regulations that were published, I just said that, they published from 2010 that were the ones that the administration put in to replace the ones that you got promulgated, couldn't be challenged because of the 6-year rule. So there are some technical legal advantages on changes that are being made. Okay, let's see what I've done here. All right, so you don't have to be told what the effect has been for you on just the changes in the minimum wage that you have to pay people over the last 3 years. And let me share with you, in case you've never looked at it, from Virginia through Florida, Alabama, and Mississippi, we are better off in terms of the wage costs, really, than the rest of the country. Out west, some of those rates are up in the $19 plus range. I don't know that fact that we are better off than some helps the bottom line, though. And I don't know that all of the commodities that we're talking about that may be affected by those higher wage rates are facing the import competition that we are in the Southeast. But all that said, a primary aim of the current people like Bob Redding and Leon, I know you're going to Washington Monday to talk with people about where do we focus our efforts. And certainly the wage rate, it ain't the be-all and end-all. It's not the final thing you need, but it's a place to start for sure, right?
Yep.
You want to talk to them a little bit about what you can say about your Monday meeting?
Well, it's, I mean, for a number of years, there's been a coalition of ag groups in D.C. that have met every week, literally for the last, gosh, almost 15 years. Yeah. And it's an effort and an attempt to get all of ag on the same page when it comes to immigration and labor issues. Traditionally, there has been, and there still exists today to some degree, a split between the East Coast and the West Coast. That's a bit of an oversimplification, but traditionally, producers on the West Coast were interested in legalization of the undocumented workforce. A lot of year-round production, a lot of folks who live in the community year-round and work, but who may be, shall we say, differently documented. In the East Coast, it was a little bit of a different scenario where there was more of a reliance on truly seasonal labor and reliance on the H-2A program. And so, again, this is a gross oversimplification, but traditionally, folks on the West Coast wanted legalization, folks on the East Coast wanted a reform of the H-2A program. so that they could use it. They don't need workers year-round. They don't need workers even in a lot of cases for 10 months. We're not talking about Florida and, southern Georgia. And so those two were at odds. You had agriculture split in what they're asking for Congress. So a dozen years ago, this coalition was formed of ag trade associations to regularly meet, compare notes, try to all get on the same page, which we have had some success at. There has been some legislation over the years that was, like herding cats or frogs in a wheelbarrow, trying to keep all the ag groups on the same page. We've never been able to finally get a bill, however, that we could get through the House and through the Senate. Some years we've gotten something in the Senate, some years we've gotten some in the House. And in recent years even, there's been sort of this old split redevelop in ag, where folks who were more interested on the legalization side under a Democratic Congress had a more favorable reception and got a more favorable bill on the legalization side without much help for H2A. So it's an intractable problem that year after year after year, it's Groundhog Day, but we are at it again, new Congress, new administration. So all these groups are getting together for a big meeting Monday to try to map out our approach for the coming Congress.
And one of the things that irritates me a whole lot is the notion that is perpetrated that these temporary foreign worker programs enable employers to get cheap labor. Ain't so. No matter whether you're talking about H-2A or H-2B or the scientists and engineers that are brought in under the H-1B program, there's nobody who uses these programs who knows it, who is going to be able to say this is a cheap labor. Well, turning to some of the pending litigation, there is a continuing challenge to the adverse effect wage rate rules that were put into effect in 2023. There was an effort in Asheville, North Carolina, to get the federal judge there to unwind parts of the new AWR. I think that was particularly focused on the higher wage rates to be required for people who had certain type of driving, over-the-road driving responsibilities for heavy trucks, for supervisors, and for some other jobs that didn't typically involve working in the production on the land or in the packing houses. That judge shot him down. That case is now pending after argument in the Fourth Circuit, which is Richmond. It did not sound like the appellants had a receptive Fourth Circuit ruling. You want to say anything about that?
I didn't follow it closely, but that was my general impression.
I'm not hopeful there. On the other hand, in Louisiana, there was a lawsuit by several of the big sugar producers, and again, some of the sugar producers associations, bless their hearts, and they got an injunction against the higher wage rate requirements applicable to the drivers of the big heavy trucks that haul the sugar cane from the field to the mills. That injunction is only applicable to the named grower entities that filed the lawsuit, and I think it's 3 or 4 sugar producer mill operator associations. And so again, hardly any business entity in farming can afford what it costs to run a lawsuit these days. And so just as in picking what you hope to get in terms of a legislative fix, it's obviously very clear you got to have safety in numbers, or the best safety you can make for yourself, and pick what you fight. And good luck to them. And that case, as far as I know it, is not yet under appeal. I think there's a preliminary injunction. I don't think there's been a final ruling. And in general terms, they got to have a final ruling before they go up to the Fifth Circuit. Yep. You know anything more about that case? Yep. We have a case pending in Tampa. My colleague, Chris Schulte, has oral argument in that case on January 24. Again, you don't know what you're going to get in a big district like Tampa. You have 4 or 5 at least judges who may be picked for a particular case based on what's supposed to be a random draw of which judges get which cases. We did not get the injunction in Tampa. The summary judgment where we say, Your Honor, take another look at this case. We think we're entitled to have you enjoin as unlawful these wage rates for, like, supervisors, as I said, heavy over-the-road truck operators, and so forth, because the law, the underlying law that goes back to 1952 says what we're here to do is to prevent, in this law, to have the H-2 Ag program, is to have avoidance of adverse effect on U.S. workers similarly employed. And when you start adding in wages of UPS and FedEx delivery drivers, we're saying that ain't similarly situated. And the injunction denial came out before the Chevron deference case was reversed. So we are optimistic, but you don't know until you get the ruling from the judge. You know, you read the last page first.
That's right.
Anything else you want to say about that one?
Nope.
Now, I'm really sorry that the folks in Atlanta who handled the case for Georgia Fruit and Vegetable Association and then filed on behalf of the 17 states that are covered can't be here first. Okay, well, I don't really want to steal their thunder because I think they're really entitled to a lot of praise and congratulation for getting those 2024 regulations, not just the parts that they were focusing on to say are unlawful, but the whole thing. And so Leon and I had dinner together last night and we're, dreaming, I guess you might have to call it dreaming, that, okay, with this ruling, can it be the springboard for going up to the new administration and say, we taught the Labor Department, you did, help teach the Labor Department in 2010, that you can't just jerk a regulation that's been issued off the table, but there are ways to do it, to go to the Federal Register and issue an analysis that we've taken another look at this case in light of the injunction and the points raised there. And we're thinking that maybe these regulations ought to be withdrawn. You care to say anything more about that?
Yeah, I would just say, so we have thus far pursued a legal approach to try to invalidate these rules, and those cases are going along very well. There is, however, with the new administration, the at least theoretical possibility that they could, well, a couple of different things. One is just completely withdraw the rule based upon the injunctions, or to say it another way, given the injunction that you all got that applies to 17 states, the injunction in the case that I brought that applies to 4 states and enough other H-2A associations that it essentially covers the entire universe of H-2A employers, plus the injunction in Mississippi that is nationwide, and with regard to that specific provisions challenge there, that given all of that, the department could say, look, this is just a mess to try to administer and figure out who's covered by what, where, and what rules and what forms. We're just going to pull the whole thing.
Yeah. Well, and I'm going to let you talk about your Kentucky case in just a minute, but I also want to say to you that case is another example of farmers need to band together in the associations because there are certain states that are covered by your injunction. If you are a member of certain organizations, North Carolina Growers Association, National Council of Agricultural Employers. Who else is covered? The U.S. Farmers, USA, Farmers,
USA
USA Farmers.
Yep.
I have a copy of the injunction order in my briefcase, but and you had to be a member of one of those covered plaintiff associations, unless you were business within one of the 3 states, I guess, that are also now covered, as of the day of the order. And so, like I say, it isn't necessarily a safe place, but there is some safety in numbers of having the associational support. Well, Leon, to talk a little bit more about what's in your Kentucky injunction, I gather that we will be able to get the folks from...
10 minutes,
okay. Again, I think this injunction in Georgia, I was thrilled to see it. It has been a springboard for some of these other orders, and maybe it can be, particularly if you add all of the associations and states that are in your Kentucky, I call it Kentucky, that's just because that's where it got filed, to be a basis to go to this administration and say, here's all the evidence that these plaintiffs put forth in front of these courts about how burdensome these new regulations are, how injurious they are. And by George, you know, if you want to talk about being energy sufficient, I'm used to eating every day, you know, and it's not that you can't grow it, but I don't expect you to grow it if you can't sell it and make a reasonable profit to continue in business. But tell them some more about your lawsuit.
Yeah, so, I mean, you really need a score sheet to kind of keep track of all these cases and what's covered and what's not and who's got the benefit and who doesn't. But I'll try to just very simply distinguish the cases for you. So you all had the first one, so if you think of the rule as being this wide, you all filed a case that, you know, covered sort of a narrow couple of issues. The injunction was granted, not just for those issues that were specifically challenged, but the injunction was for the entire rule, which is great. That's as good as you can get. But as has typically been the practice historically, if somebody runs into court and challenges a federal agency action that applies to the whole country, if it's unlawful for the whole damn country. It's not unlawful just as to the people who challenge it. Well, that approach is really out of favor now in courts over the last several years. So the judge in your case said, I'm applying this relief, but only to the people who are in this case. So that's great for you all, and y'all deserve a lot of credit for standing up and taking a shot and succeeding. Well, as a result of that, you can imagine in the other 33 states in America, people who are in the H-2A program said, hey, wait a second. We want in on that too. That's not fair. So within a couple of days.
Excuse me. I mean, just think about what the jurisprudence is. The regulation we think is unlawful, we think it's just flat unlawful. But we're not going to say vacate the regulation because it's unlawful for everybody. The practical effect is that it's just treated as unlawful if you are in that front group. And so good for you for pursuing the injunction on a broader basis.
Yeah, and so I had a number of clients who were concerned about getting some relief as well, and of course they deserve the credit because they're the ones who put up the money and the blood and the sweat and the tears, and the individual farmers who have to come forward and say this rule harms me. So we got together 5 pretty sizable ag associations with membership across the country. We brought a separate suit in Lexington, Kentucky in federal court, along with 7 individual farmers. And again, the rule covers this much. You all focused in on a few provisions. Well, we focused in on a few more. Ours was a broader challenge beyond what are generally referred to as the unionization provisions. There were a lot of other provisions really in the weeds that, frankly, unless you spend a lot of time in the swamp, you really wouldn't understand and be able to articulate the legal challenge. So we challenged a lot more than what you all had challenged, in addition to what you all had challenged. And our federal judge said, yeah, we think what the judge decided in Georgia makes a lot of sense. She was right. Our judge largely agrees with that and has copied a lot of that reasoning. And in addition, the judge said, oh yeah, you also challenged these other provisions. And he picked out a few of those and said, yeah, these are unlawful as well. And among those that I think are the most important is the new regulation related to pay. For folks who pay on piece rate, or even now, folks who don't pay on piece rate, the new rule requires, you say you want to pay on hourly because you're picking a delicate crop and you don't want folks to work quickly and bruise your fruit, so you're going to pay hourly. Well, under the new rule, the Department of Labor says, well, it doesn't matter. If they could have made more under a piece rate, you have to calculate their pay under a piece rate, and if it's more, you got to pay them for a piece rate.
And have the administrative burden of the record keeping
Right.
and calculations associated with the piece rate.
So if you don't intend to pay on production, you don't really have a reason to be tracking everybody's individual piece rate. Now, some farmers may, but others aren't. So we went to the judge and said, Judge, this makes no sense. And this was particularly from our plaintiffs up in the Pacific Northwest, who said, we're picking delicate varieties, pears, apples, cherries. You cannot have people working as fast as they want, dumping fruit into a bin. You're going to destroy the crop. It's not marketable. What the DOL rule does is it essentially takes from the farmer the ability to control how their crop's going to be harvested.
Quality production, yep.
Hands it over to the worker, because guess what? If a worker knows you've got to track their production, and if they know they can get paid by the piece, what are they going to do? A lot of them, they're going to pick as fast as they can, fill those bins up as fast as they can, and make $25, $30, $40 an hour, regardless of what that does to your crop. So we presented this to the judge. We had witnesses testify, and the judge said, yeah, this is crazy. He didn't say it's crazy, but this is unlawful. So he enjoined that provision, a couple of other provisions in the rule. DOL started to require you to provide a lot of intrusive personal information on your supervisors, managers, owners, including their birth date. They said they needed this information because it helps them determine whether or not you have a temporary need for labor. And we pointed out to the judge that it's hard to understand how my manager's birth date has any impact on whether or not I have a need for temporary labor. The judge said, yeah, you're right about that. So he enjoined that provision. And another provision that we really just sort of threw in because it was a great example of how silly this rule was. The judge seized upon this and spent a lot of time both in the hearing we had, evidentiary hearing, as well as in his opinion. And that was a change that required not that you provide vehicles with seat belts, but that you were required to ensure that every person in every vehicle was buckled up every time they got in the vehicle. Those of you who've had toddlers, you know the fun of buckling up kids in a car, how you go around and make sure a grown-ass man is buckled into his seat in the back of a van, I don't know, but the judge said, look, this is crazy. And we pointed out that that's not even required in most states. And DOL did all this under the guise of, well, we have to treat these H-2A workers as good as U.S. workers are treated to ensure there's no adverse effect. And we pointed out, well, U.S. workers don't have to wear their seat belts in a lot of cases on the farm. And in any event, the employer's never liable, and in a lot of states, even the driver's not liable for passengers. So anyhow, that was another example, kind of down in the weeds. We challenged, the judge agreed, and so he enjoined several additional provisions in the rule, but, as in your case, he applied the relief only to the people who were in that case.
Right, and so there are parts of the rule for North Carolina. I think Alabama is in your case.
Yes.
It's not covered. The Attorney General didn't join the Georgia suit.
West Virginia.
Kentucky, West Virginia. Yep. So
in Ohio.
So if you're in North Carolina or Alabama, you just didn't get as good a result as was gotten in Georgia. There's one other main case that involved an injunction. I'd have to tell you, if you think if you're not in Georgia, where it's all enjoined, even though it is applied on a national basis by this judge in Mississippi, do yourself a favor and get some legal advice before you start discriminating against somebody who has tried to bring in a union, who wants to have union business agents visit in the housing that you provide. There's some other provisions that we find objectionable. After all, I'm a management labor lawyer. I don't, you know, unions are anathema to me. But I'd also have to say that even though people who are truly in agriculture, as that's defined under the Fair Labor Standards Act, and are not covered by the National Labor Relations Act, there are state laws that give people rights to have visitors come to their homes that you provide free of charge, so that, for example, in the state of Florida, if you provide housing to somebody as an incident of work, excuse me just a minute. Chris, would you like to bring the Georgia people in so they can talk, and then, yeah.
There are several more things up there that I'd like to hear from you from. Could we?
I think that's a great idea, because I'd like to hear them, what they have to say about their case, and so, you know, we're here.
Okay, thank y'all for being close.
Sure.
We are working this on the fly as we go. Beth's going to come up and bring up Braden.
All right, well, we'll stand by.
Can I ask you guys a question? Any of the cases that are up there pending, if we got the right decision, would that roll back any of the AWARE increases that we've had since the new Big Six rules went into effect?
The case that might do it is the case that Chris Schulte is going to argue in Tampa on the 24th. And we'll talk about this when we get let these folks talk. You know, it's styled as a case by the National Council of Agricultural Employers, of which Georgia Fruit and Vegetable Association is a member, but our colleague in Washington, Chris Schulte, has filed suit on a demand that you can make under the Administrative Procedure Act that an agency consider whether rulemaking should be done. And the aim of the lawsuit is not only to fix the wage rate per se, but to look at whether or not using the new standard, the post-Chevron standard, is there an adverse effect that needs to be looked at. And I would argue to you, based on what I know, and I see people not only in the Southeast but all over the country, there are an awful lot of American jobs that are dependent on having a workforce that farmers can afford to pay, house, transport, and all the other aspects of what you do. Well, let me let y'all hear from these folks, and I have my legal pad out to take notes also.
All right. We're blessed to have great legal minds with us here, and I apologize for jumping around, but the opportunity to get to hear from all these folks is important, and thank you all for your flexibility. Next up is Braden Buchek from the Southeastern Legal Foundation. You've heard mentioned over and over the Georgia case against the DOL rules. Early last year, we were approached by Braden and his team about representing GFVGA in that case. They do that work pro bono for us on behalf of GFVGA, Miles Berry Farm, and the states that were included on the lawsuit. There were certainly, I think Braden would say, our Attorney General and others were involved as well and contributed. But Braden and his team have been driving the bus. We've had that injunction, and we're waiting on the final decision. But Braden, if I'll turn it over to you and let you tell us about where we are and what's next in the case. And let me unmute you, and we are go. Thank you, Braden.
Braden, can you hear us?
I can hear you just fine. Can you hear me?
Excellent. Yes, we can.
Great.
And you've got, you've got
Go
a
ahead.
room full of growers and professionals here.
Man, I'm excited. Will you remind me how long you want me to go with the new time limits? How long do I have?
Let's say, would 20 minutes be appropriate?
20?
Okay. You got it. Am I on? Am I?
You're on and live and ready to go. And Braden, the short answer to that is I'd like you to take as much time as you feel you need in order to communicate what you need to communicate. So you're on.
No, that's fine. I appreciate it, and I appreciate the opportunity to speak to you and your audience members again. I'm frozen in, but fortunately, I am calling you from my home office, so every day is a work day, given the new reality of how I work. For those of you who don't know, my name is Braden Busek. I'm the Vice President of Litigation at Southeastern Legal Foundation, and we represent the Georgia Fruit and Vegetable Growers Association in their challenge to the Department of Labor's rule for H-2A workers that confers a number of collective bargaining rights to anyone who participates in the H-2A program. And I'm sure a lot of your audience members have been following the litigation throughout. What I'm going to do today is just briefly update you on the status of our litigation and the related litigation that's going on throughout the country. So the rule itself, as many of you are aware, was a new regulation, not a law, that was handed down by the Department of Labor, and it confers any number of important collective bargaining rights on H-2A workers. Those are specific to H-2A workers. They do not apply to any workers that you would employ who are not coming under the H-2A program. And the reason why that's significant is because going all the way back to the 1930s, Congress sought to settle the raging debates surrounding the balance of rights for workers and for employers through a comprehensive act called the National Labor Relations Act that was enacted in the 1930s, I think 1935. And one of the compromises that it made was that while it gave a whole host of the collective bargaining rights that we now understand as well established in the labor market, it specified that its provisions did not extend to anyone in the agricultural industry. But what Department of Labor did under its newly enacted rule was confer those, but only for people who are in the H-2A program, meaning essentially, that migrant workers are entitled to a whole host of statutory protections that are not available to their domestic worker counterparts. And the reason why this is so problematic, as you all are undoubtedly aware, under the American system of government, the Constitution says that all legislative power belongs to the legislative branch. Department of Labor is part of the executive branch, meaning its role is to enforce the laws that are handed down by Congress. Now, it's well established that executive branch agencies are allowed to enact rules that have the force and effect of law, but only if they have been given that power by Congress. And certainly any rules that it enacts cannot contradict a law that has been enacted by Congress. And our argument from the beginning has been twofold. Number one, Congress never gave the Department of Labor the authority to enact rules like this for the H-2A program. Department of Labor's role is really to assess whether or not there are a sufficient number of domestic workers available who can do the job, and if there aren't, to ensure that the wages that are provided to the migrant workers do not undercut Americans' domestic wages. That's it. And what Department of Labor has done has taken that limited conferral of rulemaking authority and interpreted it in such a way that it gives it vast power. In fact, many of the powers that we're familiar with, such as setting the adverse effects wage rate, all purportedly come under the umbrella of Congress telling them that they have this limited role in certifying. So argument number one is that they don't have broad rulemaking authority. But argument two, and the broader argument, is that the rule that it enacted here contradicts the National Labor Relations Act by extending labor protections to a subset of the agricultural employee market, specifically the H-2A worker. We, along representing the Georgia Fruit and Vegetable Growers Association, filed an action on behalf of you guys in the Southern District of Georgia. And we did this in conjunction with over a dozen states led by Kansas. And we filed for what's called a motion for preliminary injunction. And a motion for preliminary injunction puts things on the fast track. It asks the court to take a quick look at the impact of the rule and assess whether or not it is likely legal. And if the court determines preliminarily that it is not, it's to impose an injunction that halts the implementation of the rule while the litigation is pending. The judge assigned to that case, after a contested hearing over the summer, granted our request for a preliminary injunction, and that halted enforcement of the rule pending the litigation. That preliminary injunction remains in effect, and the litigation has proceeded on an accelerated timeline. We have filed a motion for a final ruling. It's called a motion for summary judgment. All of the briefing on that was completed in November, early November. So the judge has it within her ability to issue a ruling at any time. The judge's ruling was specifically premised on the fact that the National Labor Relations Act prohibits the Department of Labor from conferring the important statutory collective bargaining rights that it tried to do under the rules. The judge did not accept our broader argument that the Department of Labor lacks the sort of broad rulemaking authority that it purports to enjoy here, undoubtedly because of the disruptive effect it would have on a whole host of other regulations that the Department of Labor has long maintained. Since we filed our action, there have been a host of other challenges by other states and other agricultural groups in other courts. I'm aware of, I think, 3 other ones. There was one in Kentucky, there was one in Mississippi, and there was one in North Carolina. Chris can chime in later if I'm missing any. Right now, we're looking at a completely unmitigated slew of victories. The district court in Kentucky also issued a preliminary injunction on substantially the same grounds. More recently, however, I can't remember if it was November or December, the court in Mississippi also entered an order halting enforcement of the rule. However, that judge bought the broader argument that the Department of Labor lacks any kind of rulemaking authority to do rules like this under the statutes that actually were enacted by Congress. So we have these 3 actions, all of which have operated to halt enforcement and implementation of the rule. None of the courts have actually issued a final ruling, and the court in North Carolina has not issued a ruling of any kind. That sort of things currently stand with the litigation. I can't give you a timeline as to when the judge in our case or any other cases will rule, other than to say that I expect it to happen at any time. But judges don't like being told that they need to rule at a particular time, and they will do so when they want to. The good news is that with the preliminary injunction in place, the rule doesn't have any practical significance for anybody protected as a member of Georgia Fruit and Vegetable Growers Association. I should add that one of the benefits of joining Georgia Fruit and Vegetable Growers Association is that you are covered by virtue of the fact that Georgia Fruit and Vegetable Growers Association has participated in the lawsuit. You don't need to do a single other thing other than just be a member of Georgia Fruit and Vegetable Growers Association. And, we're obviously very appreciative of Chris and your organization's contributions to the litigation. We couldn't do it without you guys. And I hope that you guys see the benefit that's been provided by the litigation. One other thing that I'll flag, Chris, you and I haven't talked about it, but I do want to talk about it at some point in time, is that the Department of Homeland Security has taken steps to enact a substantially similar rule, and even pointed out that Department of Labor has enacted this rule without mentioning that Department of Labor's rule has been struck down by every court to consider it a question. So one of the things we want to talk about going into 2025 is whether or not we need to take steps to directly address that rule. Undoubtedly, some of your members have questions about how the change of administrations is going to affect those rules. I'm happy to answer specific questions there, but the general answer is nobody knows. Of course, an incoming administration has the ability to reconsider its prior positions, but it is not as simple as just saying we don't want to go forward with the rule. Any rule that was enacted under the Administrative Procedures Act can only be repealed by complying with the Administrative Procedure Act, which ordinarily means they need to propose a new rule repealing the old rule, and that's got to go through a lengthy procedural process before it becomes the law of the land. Now, there are some options that are available to an incoming administration, given the fact that there are court orders out there, and they've obviously got to obey those so they can reconsider some of their litigation positions. That's got some legal complications to it that we don't need to go into today. I just flag it as it's not as simple as the administration just deciding it wants to give up. And on top of that, in the past, we've seen that it's very difficult for a change in administrations to get their arms around all of the things that the last administration did that it would like to undo. And we don't, on top of it, know exactly how this Secretary of Labor is going to feel about this particular rule. So there's a lot of questions about what the political side of the question will look like. Another reason why we need to protect ourselves by continuing to use our litigation efforts. We have every intention of sticking with you guys as long as it takes. And I'm sure you guys know this, but all of our litigation is provided to you guys totally free of charge because we are a public interest group, and we staff and fund our litigation purely through the generosity of our donors. So that in a nutshell is where we stand. Perhaps now is kind of a good time to open it up if you guys have questions or you want me to focus some of my thoughts and comments anywhere else.
Any questions? If you guys have any, I can pass them along to Braden. He can hear me, but he won't be able to hear you in the audience. But anything I can pass on to Braden? Yes, sir. Is there a way to expand the web of inclusion in this injunction? Like, want to add other states in this particular case? Okay. The question, Braden, is there a way to broaden the injunction so that other states or other growers or other entities could be covered?
Yes. Ostensibly, my read of the Mississippi order is that it did that. It applied to everyone. I don't know the Department of Labor is enforcing it that way. I don't know if there's anybody that it thinks is covered. I'm kind of curious if you guys know the answer to that question. However, we have argued to the judge that if she issues a final ruling in her favor, the proper thing to do is to just totally strike out the rule, essentially, which would mean that it has no legal effect to anybody anywhere. The second point, and I don't know if this is what the audience member is driving at, but we design cases to leave a precedent and then use that precedent to springboard forward into other areas and other topics. We've got a good precedent here. The one in Mississippi is potentially even broader. And so in 2025, we want to talk with you guys and other growers and growers associations about what are the ways that we want to take advantage of this precedent that we've achieved in ways that will meaningfully help you guys continue to do the important work of putting food on America's tables. Because there's real opportunity here to use this to exploit a lot of the things that you guys have probably taken for granted you have no choice but to comply with. Because I'm not sure you do, especially in light of the Mississippi ruling. That's the one that's really got me interested, as you can tell.
Okay. Here's what gets me interested. You can tell Braden understands the problem and understands our industry and gets the culture and knows that where we're going with this is we're losing the ability to feed ourselves.
That's right.
Yep.
Yep.
I'm I'm going to make a plug for Braden too. As he mentioned, their work is supported by the generosity of donations and supporters. The organization again is the Southeastern Legal Foundation. If you go to their website, you can follow along with the GFVGA case. You can access all of the documents that have been filed by all sides and all of the orders issued by the court. But would certainly invite you to consider supporting Southeastern Legal Foundation. We value the partnership, and as Braden says, we're trying to look at other areas going forward where we may be able to continue to make a difference for you guys. So, Braden, how about we give you your Saturday morning back? I bet you got some folks that want to get out in the snow.
Nope, I've got teenagers, so no one's up yet. So you've got me as long as you want me. One other thing that I'll put on your radar screen, and Chris, you and I should set aside some time in January to start to think about what we want to do next.
Yep.
But one thing that the incoming administration does offer the potential for is proposing new rules and repeal of those rules. They're going to be a lot more sensitive to protecting the interests in domestic food production. That seems to me to be fully aligned with this incoming administration's priorities. So, I mean, you guys are probably used to just the Department of Labor telling you what to do and waiting to see what happens. We have a rare moment here where we can work with an administration to reconfigure the way in which the H2A and other programs work. And one very interesting thing for all of you to consider is, as I said, the state that has led the charge with us in this is Kansas. I know of two key figures in the state of Kansas Attorney General's office that have participated in this litigation that are leaving to assume high-level positions in this administration, which means we are uniquely positioned to propose profound changes to the way that this program has worked to make sure that it works better for you guys, which in turn means it works better for Americans who have shown that they care a great deal about the bottom line on their grocery store bill.
Okay. I may have one other question. Courtney?
We do to lower AWR rates, or maybe not get them lowered, but over the next 3 years, not have a 32% increase the way we have the last 3 years. Are we hopeful of that at all?
Yep. So.
Tell a different lawsuit. What's that look like?
Yeah, so it was a broad question. I'm going to try to answer some of it, and then that may tee you up, Braden, for a little bit more. But the question was, working with the new administration and the new Secretary of Labor, what is that going to look like, and will there be opportunities there to perhaps impact and affect some additional change? Here's the thing I would say. We all have a very positive outlook about the Trump administration coming in and the ability, just based on the past history of his previous administration, their willingness and desire to work with agricultural producers and their understanding of the importance of keeping America fed and having domestic food production. So there's an opportunity there, absolutely for sure. I think the answer is, how do we best kind of dovetail the legal efforts that Braden and his team are doing, and Leon and Ann Margaret and all these other suits that are out there? How do we dovetail that with the political side, with the agencies, and our work with Bob Redding and others? And quite frankly, I think the most important thing there is for ag to speak with a unified voice as we go into this process, and that's both with H2A and the Department of Labor, but certainly as we look to Congress for some possible ag reform and congressional action. It's up to us to make sure that we're all singing from the same page or same sheet of music, because if we're not, then it's easy for these agencies and it's easy for our Congress and our Senate to just kind of ignore us. You know, if we come asking for multiple different groups come asking for different things, they can't help us. So most importantly, I think, is we got to get on the same page. Braden, anything to add to that?
I echo those comments in their entirety. Just to totally reemphasize the point that I made earlier, I do think we have a moment to profoundly change the way in which the H2A market and the greater ag market works. We absolutely should try to take advantage of it. We should think about the most profoundly consequential and beneficial things for you guys, which will benefit the American people. We can do that through litigation. And we do not need to just resort to legislation. Congress is dysfunctional, and it's, that I would not, I don't, it'd be great if they do something, but, I don't count on it. But we do not need Congress to act to change the rules at Department of Labor or any other agency. We are willing to propose rules. We've done this for partners in other industries that can profoundly change the way in which you guys are regulated by the key agencies. And the H-2A the way the H-2A program works, I'm sure you guys agree with me, is broken. It's been wrong for a long time. I've heard from you and others that the adverse effects wage rate is really a killer for you guys. That's a great starting point to try to figure out how to do that a little bit differently. And I actually think that the big, Twitter dust up that you recently saw over the H2B or HB1 or whatever it is program was a very constructive debate because it brought all of these competing interests to the fore. I really think there's a way to thread that needle, to balance our interests in making sure we have competitive imported labor and also making sure that employers have access to the best talent without undercutting American wages. But I think it requires a reconsideration of the way in which we determine the adverse effects wage rate. I think that's one of the absolute first things we've got to talk about. So let's definitely do it. Let's take advantage of the historical moment. Nothing moves fast in either litigation or the administrative process, but we're here to do that with you guys for free. I think my best practical advice for the audience members are to get on the same page and to convey their concerns to you. And then you and I need to strategize about what's the most high impact.
Absolutely. One more question.
Is there any,
Right. Yep.
so is there any, speaking of that, how they're going to do that different, or is there any reflection of that?
The question, Braden, is if you think back to the OES, and I call it the disaggregation of wages, that was begun under the first Trump administration. It's continued through the Biden administration and gotten more out of hand. I think Leon can speak a little bit more to that in the cases that he's got ongoing as well. But the question I think to you, Braden, was is that an area, again, where we can look to deal directly with those members of the administration who are familiar with this and see if we can affect some change that way too?
Yeah, everything's on the table. We do think we've got direct access to key figures who can push the administrative process along and get Department of Labor on the team. Okay. So we think we have unprecedented opportunities. I would just, again, urge these individual members to talk with you and start setting priorities internally. And then you and I, sooner rather than later, should get together and decide what we want to do next.
All right. Well, we're headed to D.C. for the inauguration on January 20th. So let's see if we can visit before then, and we can go ahead and get to work.
Yeah, not much is going to happen until the inauguration, but after the inauguration, things are going to happen real fast.
Absolutely. All right. Well, Braden, thank you so much for joining us on a Saturday morning. Everybody give Braden a hand. We couldn't do this without him. Thank you, and we'll be in touch soon. We're going to once again pivot back to Ann Margaret Pointer and Leon for just a few minutes. They've got some important things they want to talk about. One of those is a GFVGA initiative where we have built a coalition. I'm going to let Ann Margaret tell you a little bit about it. But we are now up to over 30 state, national, and regional organizations that have come together with us in an attempt to, this effort is aimed squarely at trying to gain a better understanding of the labor survey and how DOL and USDA uses that data to come up with the AWARE, where we've had the 31% increases over 3 years. No one can tell us that. No one is willing to tell us that. So we're going to keep demanding that. And now we've got 33 groups across the country, including Georgia Farm Bureau with the Rainer in the back there, that are contributing financially to get that off the ground. And we're going to work with Josh and Ann Margaret at Fisher Phillips on that effort. So I'm going to turn it back over to them, and we'll keep going. Thank y'all.
Okay. Well, Courtney, I'm so glad, frankly, that you brought up the issue of this wage rates based on payments to Federal Express truck drivers is not protecting U.S. wages of similarly employed U.S. workers, in my mind.
Truck drivers and
You name it.
have a gamut of the OES wages.
I don't know if the rest of you can hear her, but she's pointing out a mechanic who works on a farm all year long comes in to help with the seasonal need is not the same guy as the guy who is working downtown to keep an over-the-road or Federal Express truck operational. And so I'm just a lawyer. I'm not a lobbyist, but I am an observer of the passing scene. And some of my worry is that there are people within this administration who not only don't care, I think, they affirmatively want to be rid of the H-2A program. And I think in that Heritage book, Leon, isn't there a date that they want it done by? It's by the end of this decade, I think. And so anybody who thinks that forcing U.S. workers back into the field is going to happen isn't somebody I can sign on to, because it's not real. And I have had to defend for farmers terminations of workers who clearly didn't want to be working at those farms. They were doing it just because if they didn't, they couldn't sign back on to get unemployment. And you know, it's a terrible reality. But I think the H-2A program, or some version of it, is the only way we're going to have hand workers in agriculture for the future. You got any thoughts about worrying about some within this administration who not only don't care, don't want this program?
Yeah, I'm going to choose my words carefully. I think
you do, and I perhaps said more than I should have. Let's just say it's a worry, and if you, in your position, have got to stand back, I can understand that.
I've been known to get wound up at sessions like this, and
but
there's press in the room and things appear in the paper that don't.
Yeah, we need you to keep your cool, because you got to negotiate with those people.
I'll say this, there is a general assumption among my clients, among agriculture community, who tend to generally support the Trump administration and believe that the Trump administration is going to solve all of their problems based upon sound bites and clips and very generalized statements, which would lead one reasonably to that conclusion. It's a lot more complicated than that. And your example in the first Trump administration is actually the one who came up with this, well, I'm going to say not well-reasoned idea to segregate out certain job categories and pay different wages. I mean, the Biden administration ultimately implemented that, but it wasn't their idea. The Trump administration, in my view, in the first term, suffered from a lack of political personnel in the agencies, including DOL. There's a general view of, oh, well, I'm just not going to fill these positions, we'll reduce the bureaucracy. That ain't the way it works. I've been in the building, I know that building runs by the bureaucracy. If there are no political staff there to shape and guide and point folks in the direction that the administration wants to go, they're going to follow their own agenda. And so if you don't have it fully staffed up with political appointees, there was an old saying, this wasn't unique to the Bush administration, but the old saying in Washington, and this mantra was repeated over and over when I served in the Bush administration: personnel is policy. The people that you have in place are going to effectuate your policy goals. If the Trump administration does or doesn't have people in place, they're not going to accomplish what they want. Now, and Margaret raises another valid point as to whether the folks who fill these positions, where are their policy preferences? And the president-elect makes very hopeful and broad statements about things that leave you encouraged, but what are the people in the agency who are directing the work actually doing, and are they all on the same page? So
in other words,
it's going to be
we will
difficult,
see. But
yes.
Courtney, I know that you will be in the forefront of trying to help people understand it doesn't all just come out of Publix. You know, it's not you know, my grandfather, both of them could give speeches on what you're talking about. So moving on, the litigation that our colleague Chris Schulte filed right before Thanksgiving in Washington is designed to bring to the fore with the Labor Department an issue over what is adverse effect, what is it we're trying to prevent, and what is the kind of wage rate that is necessary to support the avoidance, that's what the statute law says, avoidance of adverse effect, and how should that data be collected and analyzed. Right now, the farm labor survey that is done by the Department of Agriculture is just not the basis upon which to create these wage rates that you all have had to endure, particularly over the last 3 years. And again, giving the, if you will, the devil is due by Yellow Jacket household. Chris Butts has been a bulldog on bringing people to mind to, like, the Southeast simply cannot continue to produce the variety of fruits and vegetables that we do and sell them and not make a profit. So that's my thought about that. Talking about where we are in the litigation, I was just getting to talk before we were able to get to the Southeast Legal Foundation people about the scope of the injunction in the Mississippi case. And I was saying to you, there's some states that already give employees who live in employer housing certain rights to have guests of their choosing, and that may override and make certain parts of the, if you will, the union business agent access to your workers' housing, that override that part of the injunction, important as it is. I mean, we don't want to give up the exclusion of the agricultural workforce from the federal National Labor Relations Act. But I'll tell you, if it were my farm, and I heard that there were union organizers in my camp, I would not call my brother-in-law's second first cousin, who's the sheriff, and say, get some deputies out there and get that guy out of there. Because I've seen enough court cases where that has come back to hurt the farmer, landowner, from the standpoint of litigation, of removing people who were invitees of the residents in particular states under force of law. And then again, whoever your market is, and I know many of you are subject to the social audits by your customers, they don't want to see it either, having people thrown off of farm premises. You need to be smarter than to take that kind of action in a precipitous way. So if you don't have legal counsel, you don't know what the state of the law is in your jurisdiction, resist the temptation at 9:30 or 10 o'clock at night to take action to get somebody pushed off. And you know, there are people who, you know, their dues paying members support their compensation and their job. And so they got a real incentive to unionize your workforce. At the same time, you have an incentive to have a satisfied workforce that recognizes that you do your level best to provide great working conditions. I happen to have known the McLeod family, not from working for them necessarily, but because they have just great peaches. And, you know, I had never actually met Mr. McLeod face to face until this morning. And, you know, he doesn't have any problems on his farm, is my likely opinion, because he makes it clear he wants everybody on the farm to make a good living, live as well as they can, and if there's a problem, let me help you solve it. You know, I don't want you, you know, in a place that needs to be repaired. Another thing I would say to you that is enjoined in this Mississippi suit, one of the provisions of the regulations is if somebody comes into you and you're saying, Joe, I think you have, you know, torn up my last transmission on that tractor you were operating. I'm just going to have to suspend you or some other disciplinary action. He says, well, I have a designated representative that I need to have here to meet with you to discuss my discipline. Again, don't call the sheriff, don't throw him out. If that happens, where somebody says, I want somebody with me while I'm talking to you, he says, well, let me consider that. Let me check it out. And then you get with a lawyer or somebody who's knowledgeable on this to understand if you're not in Georgia or a member of Georgia Fruit and Vegetable Association or covered under this injunction. Now, this provision right now is enjoined from the Mississippi case, but if for some reason that should be overturned, I can't think of a reason that, unlike the invitee, the state laws that allow people in some states to have their own choice of visitors, I can't think of a state law that would override that injunction on that point. Can you? To say you've got to have allowed to have a designated representative with you. So, but this brings up just another issue, and you may have some comments on this also. More than ever before, I would say you need to be in tune with your associations. If you use an agent to file your job order, or you know somebody who does, make sure that agent knows what the state of the law is for your operation at the time that you need to file a job order. Because I've got cases I've worked on in the last 2 weeks where I believe the employer who said, my agent never told me X. And I'm thinking to myself, you know, I think I believe you. But you might have been using an agent who wanted your business so much, the agent did not tell you what you were signing up to do or not to do. I don't want to cast aspersions on anybody, and my goodness, there's a lot of this that you read it and you hear about it and you say, well, that could be interpreted this way or that way. Well, there's some things that, for example, paying for the worker's transportation all the way from his home village to your farm, that's not new. I don't see that changing as long as the Department of Labor is considered to have any prerogative at all to regulate the terms under which you can bring H-2A workers. But make sure that if you're working with an agent, you're dealing with somebody who keeps up with what the regulations require. You got any thoughts about that?
Nope, I think that's good advice. And, you know, I would also add to that, just because you hire a lawyer doesn't necessarily mean the lawyer knows what they're talking about. I have inherited a lot of cases that people had their local lawyer who's helped them with their wills and their trusts and their land deal and their insurance business. All of that's great. There's lots of smart lawyers, but just because you have a law degree doesn't mean you know everything. Make sure if you're going to talk to a lawyer, it's a lawyer who knows labor and employment law, and if you're going to talk to them about H-2A, make sure they know about H-2A. This is a very particular area of the law that just having a law degree doesn't mean anything. In fact, I know a lot of agents who know 10 times as much as a lawyer about the program because they're in it every day. So,
well, that's right. And among the things I like to do is to talk with knowledgeable agents because they deal with the Department of Labor and the USCIS every single day. Yep. And you sometimes hear of the Labor Department, because these are contract workers by and large, not employees of the Labor Department. Some of them are even part-time. But they get out of line with what the agency even, the administrator of the agency says. So good advice to be on your guard at all times in this area. Beth, I think we've got Professor Brown to talk with us about, and so as you figure out whether you can afford the H-2A program, we also need to know what you can sell your commodities for and what commodities are manageable. Yes, sir.
A lot of this, I mean, basically the entire talk is all about the adverse wage rate. I'm wondering if anyone ever really considers, I guess in 2020 when the USMCA really strengthened the free trade between us and South America and Mexico, it's almost like a double whammy of we're getting hit with all these wage rate increases, and they're getting relaxation on their trade into America. So I think that creating the market value of our crops that are not moving or even going down in some cases, as like a pepper farmer, all the corporations are just not growing here anymore.
Right.
And so I feel like the urgency of the wage rate is like so imperative to even keep farms going in America when you bring in these market prices almost dropping. So like that, I think that's a lot more important than people think of, especially tariff free when we're now the new buzzword is tariff. Like it was like in 2020 it was relaxed, I guess. So I don't know if that's ever talked about, or I never really hear about that.
Yeah, I would say, to sum up your comment in one sentence, is the federal government is doing nothing to protect specialty crop farmers.
I would say not nothing. I would say they're hurting.
You're right.
They're objectively hurting, and they're trying to say like the adverse against wages. They're going adverse against American farmers on both ends.
You're right. They're making it easier for imports to come in, and they're making it harder and more expensive for you to produce here. You are absolutely correct. Yep, absolutely correct.
Well, that's not a happy note to end it on. I think we do need, as an industry, to spend more time helping the American consumer understand that their food doesn't come out of Publix. I mean, just to be very frank with you.
And I'm a little nervous that the new economists coming in are super globalized, laissez-faire minded. That like, oh, now this is like the complete cheapest way we can do it. So that's the best for the American people. But it's like, this isn't.
Right.
I'll stop ranting.
No, you are preaching to the choir. Yes, that's what we'd say.
Tell us if we're optimistic and we think this wage rate could potentially be reduced sometime in 25. How can we write a contract and bring workers in timely before that happens? It gives us the flexibility to take advantage of the lower pay market.
Yeah, so the question, I think as I understood it, is how can you prepare your contracts for the upcoming year in anticipation of a potential reduction or freeze in the adverse effect wage rate? Is that?
I'm going to tell him what I think.
Don't
count on it.
Yeah, I mean, was trying to.
Just don't count on it. And worse.
That's easy. I mean, you maybe are saying we can't do it, but we as business people have to look forward, and we have to say, if this happens, and I don't prepare my contract for that, it costs me hundreds of thousands of dollars. So how can I do it? Maybe I can.
Well, one thing to be aware of under the regulations that have been in effect under this administration, going back to 2022, once you name a wage rate in your job order, even if the data came back saying it's really not $16 an hour, it's $15, you can't change that. You are not permitted under the regulations to do it. That makes no sense to me. And what other part of the... Pardon? You got to change the damn... Pardon me. You got to change the regulation to change that part of the result.
Yeah. So
That's the problem.
The answer to your question is yes, it is possible. Realistically, it's highly unlikely. I mean, I've been at this a long time, and I'm a realist, tempered with a healthy dose of cynicism from living in D.C. for 20 years. It just is not likely. The safe bet is to bet on the status quo. And if something improves, hooray. But I would not count on it.
That's why I'm hoping, like, scratch going down until those regulations are changed. I'm just hopeful we're not gonna go up, or go up as significantly as we've gone up the last 3 years.
But I'm going to tell you, if you're my brother-in-law or sister-in-law, you take your fine point pen or your spreadsheet and figure out whether, based on what is likely, you can grow that commodity anymore. Whether or not it is.
Go ahead and pencil in 5% over the next 3 years, or 15, or 23, or what percentage?
Well, I'd ask the economists what the numbers look like, but you've seen what the rates are over the last 3 years for the Southeast. I mean, not a pretty sight.
Yeah, it's hard to run a business that way,
Yep.
which everyone in this room feels.
Yep.
Well, thank you, though, for what you do. I always look, I say Publix, my neighborhood is ringed by 3 Publix. You just can't get to anybody else where I live, which is fine, because they do a good job, generally speaking, of supporting American growers. But I did reach in where I normally pick a package of blueberries and was startled to see that they were not American grown. So, you know, you get those kinds of surprises for sure. But I hope you can find a way to keep producing the fruits and vegetables that go on my table and my grandchildren's table, and that we do find a way before you say, I'm just not doing this anymore. Just too much risk for me.
Well, at the end of the day, until we educate the consumer more, they're going to go buy what's cheapest.
That's right.
I ask friends who are not in agriculture like me, they don't look at if it's Mexico or Peru or the United States. They're looking at price.
Yep.
I mean, that's just where we are, and there's so many consumers that just aren't educated.
Right.
Exactly right.
They are at my table.
Well, yeah.
That's where I guess, doing that isn't enough for sure, but that's certainly where we start.
Yep.
Well, thank you all.
Thank you.
Which is a perfect segue to Dr. Blake Brown. If you were here at all to see Dr. Gopi Munasamy, he got iced in Athens, so he will not be with us today. Okay, good. But I feel like several of the questions and the way that the conversation has been going is the perfect segue for Dr. Brown. He has been with the North Carolina State University for several years. He spent much of his career as a policy analyst working on farm policy. And back in 2018 and 19, he was actually invited to be the senior economist for the Council of Economic Advisors in the executive office of President Trump, where he focused on agricultural policy. So he's got a really strong thought process, possibly to address some of your questions, Mr. Pepper Grower, and some of the others. He may not be able to change what it is, but he can at least give you a pretty good look at what's going on behind the curtain. So, Dr. Brown, come on in.
All right. Thank you, Beth. Good to be with y'all today. I'm actually supposed to be retired. I haven't really figured out how that works yet, at least my family tells me. So, but we slid out of the mountains of North Carolina yesterday ahead of the storm, and I sent a text message to my daughter-in-law this morning. I said, how much snow did we get? Well, we don't know. We had over 5 inches last night, but the wind's blowing and we can't tell. So anyway, it's good to be in warm Savannah this morning. Anyway, let's talk a little bit more about this. What we were just talking about is a perfect segue to talk a little bit about what the impacts of the AWR are. Because it's been going up tremendously, and you kind of know you're in trouble when you've got an AWR that's $16 an hour, like in North Carolina, or right at it, and farmers are relieved that in 2025 it's only going up a little bit, you know. So that's kind of where we're at. I did work in the Trump administration on the Council of Economic Advisors, and I can tell you labor was one of the hot topics. And it is an incredibly difficult topic. It was very, very difficult to get agreement within the administration, you know, and then you can imagine if you go outside, you know, what difficulty that is. There were some very good ideas bounced around in the administration. Jerry Kushner had some really good proposals, but it was very hard to get them to get on the same page. But having said that, as we go through this, I do think there are some real political opportunities. I don't know what will happen. Next year's going to be a year of a lot of policy uncertainty in general in agriculture, not just around labor. We're going to have to wait and see what this new Secretary of Agriculture, what her feelings are. Hopefully she's a pro-farmer Secretary of Ag from Texas. Sonny Perdue was extremely effective in getting Trump to do what he thought he needed him to do. More effective than most most of his cabinet members, rather. So we'll see, but I think we do need to be prepared to try to work with the administration to help them understand this. And, you know, if some of these tariffs go forward, and if some of the mass deportation that we've heard about does occur, it's going to be imperative that we get in there and talk about, you know, how it impacts ag and what you're going to do to help us mitigate some of these impacts. So with that, let's talk a little bit about this. The North Carolina Chamber, Ray Starling, who was part of the Trump administration too several years ago, and then assistant or chief of staff for USDA, he's the one that proposed this. And so the North Carolina Chamber, the North Carolina Growers Association, the Georgia Fruit and Vegetable Growers Association, and the Michigan Asparagus Growers put together some funds, and they asked me to work together on this project to look at what really are the effects of the AWR and how has it impacted fruit and vegetable production. Not just farm profits, but kind of the whole economy. So that's what we've done. And preaching to the choir, but you know that labor expenses are a huge share of our production cost. In fruits and vegetables, in fruit and tree nut farming, they're almost 40% of the share of the cost of production. If you go back to vegetables, then you're talking about just under 30%. And in North Carolina, where tobacco is still imported, it's about the same as vegetables, almost the same in terms of the cost of the share of production. So it's very important, and for our crops, the ones that we address in this room, that seasonal labor is extraordinarily important. If you look at what AWR has done around the country, here's where we're at in 2024. You know, you had some states that were over $18 an hour, like California. You had states that were 17 to 18. In North Carolina, we were, for example, 15 to 16. And you guys were the good guys down here, man. You all got under $14 an hour. Now, I've talked to a lot of different groups, and I went to the Wake Forest School of Law and talked to them, I guess, last year. And what I told them, I said, you know, you need to think about the impact that this has on those H-2A workers, what an opportunity this is. And sometimes I think we need to talk a lot about that more so than maybe we talk about the farmers. Maybe they would care, because this program provides them an opportunity to come to the U.S., work 5 or 6 months, and make more money than they can make in 4 or 5 years in Mexico. So I often tell folks this is one of the best foreign aid programs we have. If we would just make it workable, you know, for those of us who want to use it here in the U.S. And I told this the students at the Wake Forest School of Law, I said, you know, minimum wage just went up to $15 in Mexico, and it had at that point last year. And I said $15 a day. And their choice is they can stay there, and if they can get a job where the minimum wage is enforced, they can make $15 a day, or they can come here and make $15 an hour. Anyway, I'm getting on my soapbox. So we've seen the use of H-2A really, really skyrocket. Part of that has been stronger enforcement of the border and stronger enforcement, of pieces of legislation against undocumented workers. But we still have a lot of undocumented workers in the United States. Now, I think that probably if you looked at the fruit and vegetable, fresh produce industry, and say tobacco and sweet potato farms in North Carolina, you probably wouldn't see very many, because most of these undocumented workers are perhaps workers who have been here for decades, and they may work in the livestock industry, or they may work in non-seasonal work elsewhere. And so they've been flying under the radar screen, and so all of a sudden, if we go towards, some facet of mass deportation, and I don't know how that's going to work, then it's going to have a big effect on agriculture one way or the other. It frankly might not affect us as much in this particular industry as it will other segments of agriculture because of that, but it may be an opportunity to talk about, if that's where we're going, we need to make this special visa program more workable. That may be a really, really important opportunity. I don't know. We'll see. Well, when you look at the AWAR and how it has increased so rapidly over the past, say, 10 years, what are some of the effects of that? Well, first of all, it does affect consumers, and I'll show you in a few minutes that if we had a lower AWAR, it would have a price effect at the grocery store. People would eat a little bit more fresh produce, but they'd eat quite a bit more U.S. fresh produce rather than it coming out of Mexico or somewhere else in South America. U.S. produce industry output obviously would increase. We have affiliated industries that would grow. And you know what? There would be more people employed in these industries. In fact, if they made the H-2A program more workable, as we've talked about, we would bring in more H-2A workers to grow this extra produce. So there would be a lot of different people that would be benefiting from this. And as I'll show you, imports and exports. Here's what imported fruit and vegetable imports look like back in 2000 on the far side of the screen there, your left side. And here's where those same categories are in 2017 to 2019. Now, we've got bananas on here, and I don't know anybody that's growing many bananas. But look at, fruits and vegetables. Look at how much more we're doing now than we were then. And, part of this is seasonal. We do get blueberries in the middle of winter from Peru now and other places. But most of this is just the fact that we are not as competitive in the U.S. because of our cost structure, and so we're bringing more imports out of Mexico. And yes, NAFTA had a huge impact, and USMCA has had a big impact too, and you all didn't get a lot of protection under that. So I would use that as one of my trump cards as well, the play on words there. But here's the AWAR and where it's been since 2012. So it's risen over 50% in nominal terms. This is the national average, and we were on a national average of 1755 last year. Back in 2012, the national average was 1080. So it's gone up a lot more than the inflation rate, a lot more than a cost of living rate. And one of the questions that we ought to pose is this survey we use, NAS, it's almost like it just fuels the whole thing, because we survey current ag occupations, decide we got to raise the rate, we raise the H-2A rate, which, are you going to pay your H-2A workers any more than you pay your other ones? That doesn't work, does it? Because it's mutiny on the farm. And so it goes back, and it just makes this thing almost spiral, I think. And I think that's something we need to work on as well, looking at that. But we said, what if the AWAR since 2012 had increased by the cost of living? Reasonable, right? So every year you get a cost of living increase. That's the way a lot of my raises worked. I don't know about people in other industries, but that's typically the way that works. What if we had just went up by the cost of living? So what would the AWAR be? Well, if we just went up by the cost of living every year, then in 2022, which is the year we have a lot of data for, is why we chose that, the AWAR would have been $12.48 an hour. And what did we just say it was? 2022, let's see if I can go back real quick here. Yeah, in 2022, it was $15.56 was the national average, right? So that's quite a bit higher than $12.48, isn't it? Now, we have to make allowances for California. We all know that we always have to do that, right? California has a minimum wage of $15 an hour. So what if we just increased the AWR by the cost of living in every other state except California, and in California we increased it to $15 an hour instead of $18 an hour? Where would we be at? The national average would be about $12.77 per hour. And so what we did is we decided we would pose the question, what would be the case is if we had an AWR that was only $12.77 per hour rather than its level of $15.56 an hour in 2022. That's a almost 18% reduction in the AWR if it had just went up by the cost of living. Okay? So here's the question that I tried to help them answer. What would be the economic impacts of a 17.9% reduction in the 2022 AWR? And again, the background of that is that if the AWR had went up by the cost of living every year, then it would be 18% lower. Even with California's $15 minimum wage, it would be 18% lower than it actually was in 2022. And so we put together a economic model and tried to basically set up the structure of the way the economy works in the U.S. fresh produce industry, and there's a lot of background, a lot of data, a lot of parameters that we can pull from that. And so we ran it, and here's some of the results we got. These are percentage changes in some of these categories. First of all, demand for U.S. fresh-grown produce. The green bar is vegetables, the yellow bar is fruit. And yeah, I get it. A 1% doesn't sound like it a lot to y'all, but let me show you the numbers in a couple of minutes, what 1% is, or almost 2%, in vegetables. Exports of U.S. fresh produce would go up some too. Now look at fresh produce imports. They go down by almost 2% on vegetables, and yeah, they don't go down huge in terms of percentage terms, but I'll show you the numbers in just a minute. Total demand for U.S. fresh produce goes up. So people actually eat more fresh produce because of this, because there is a small price change here. And in fact, if we looked at the price change, it went down by about 0.5%, I think it is, on fruits, and about 1.5% or something on vegetables. That's, again, may not sound like a lot, but it makes a big difference. Now, this is just a reduction in the 2022 AWR rate, not assuming any change in other wage rates for farm workers. But I think we can make a strong argument that if the AWR had not gone up like it did and NAWS wasn't structured like it was, that other farm wages wouldn't be quite as high either. They would perhaps be lower. And so I'm going to show you in a few minutes where we ask the question, what if all farm wages just went up by the cost of living and, they were 18% lower than they are currently, or in 2022. So we'll look at that. Now look at H-2A employment, way up. So if you want to help Mexico out and you want more money sent home, then here's one way to do it. You can see an increase in employment. More people would benefit from that. And here's some of the numbers associated with that. The baseline levels, the quantities are in millions of pounds. So when you look at demand for U.S. fresh-grown vegetables, for example, we said that just decreasing the AWR, not even talking about a decrease in other farm worker wages, that would bring a change of about 641 million pounds of fresh produce produced. That's fairly significant, right? If you looked at exports, you'd see them go up a little bit, but look at imports. You would see a decrease in imports of about 258 million pounds. And this is just vegetables. This is not fruit, okay? So this is just the vegetable sector. The price index, you'd see about a 3% or it's an index. It's not almost a 1% decline in prices of vegetables. And then domestic farm employment, it goes down just ever so slightly, not anything to even talk about. But H-2A employment, look, goes up by almost 6,000 positions just because of this one change. Now, with all the other things going on, if we had this change, I suspect it would be bigger than that. If you look at the value of U.S. vegetable production here in the United States, it would be increase about $143 million. And so in my book, that's fairly significant when we start talking about that. Here's fruit, same question. Demand for U.S. fresh-grown fruit would be a 0.62% increase in demand for it. That's about a 94 million pound increase. Not huge, but pretty significant. Imports would go down by about 70 million pounds. People would eat a little bit more fresh fruit, from the United States, but also in general. And then when you look at the quantity supplied of U.S. fresh fruit, it would go up by about 113 million pounds. So that's how much more we would probably grow if we had a lower AWR. Domestic farm employment does go down some in this case with fruit. And remember that a lot of that are undocumented workers, and if they're going to start mass deporting them, and we're going to see a decrease in that anyway, then we need some way to bring in more workers, because look at the demand for H-2A employment. Just with this change goes up almost 5,000 positions. And the value of fruit production in the United States goes up by about $60 million. All right, well, let's ask a different question just a little bit. We can say, as we talked about, the way the knowledge survey is structured, at least a lot of folks think that it kind of creates this upward spiral because it's almost circular in the way it determines the wages of both other farm worker wages as well as H-2A, because as y'all know, you can't pay, well, you could, but it would be like mutiny, right? If you tried to pay, a farm worker that's been living here for 20 years and works for you, and you're going to pay him a lot lower than the guy that you bring in for H-2A, which also may have been coming for a number of years. So what happened if just in general farm worker wages had gone up by the cost of living rather than going up like they have? So we look at that same question, looking at an 18% decline in both wages, in all farm labor wages, and just see what impact that would have. And of course, as you might expect, it has some pretty big impacts. You see that demand for U.S. fresh-grown vegetables will go up about 5%, fruit about 3%, and we'll look at some of the numbers in a minute. Exports would grow up, and this really does have a pretty big impact on imports of fruit and vegetables. You'll see that vegetable imports go down by over 5%. Fruit doesn't go down by as much, but it still goes down significantly. And look at domestic farm labor employment. I mean, this is always an argument about minimum wage, is because when you raise the minimum wage, you always eliminate some of those workers that are at the lower end of the income earning thing. It benefits those workers that were higher up. It rarely benefits those that are at that point. It basically just causes them to be unemployed. And so if you did this, look at how many more workers you would employ domestically as well as H-2A. You would be talking about 11 or 12% increase in the vegetable sector in terms of the number of positions needed and being brought in by domestic workers, in addition to, pretty substantial increase in H-2A workers. So let's just look at some of those numbers. If you look at demand for U.S. fresh-grown vegetables, that would be how much y'all can sell. It would go up by about 2.4 billion pounds. So it's fairly significant when you get to this level. Exports of vegetables, 135 million. Imports of vegetables would go down almost 1 billion pounds if this were the case. And total demand for U.S. fresh vegetables would go up by 680 million pounds. That's how much more fresh vegetables folks would be eating in general. Quantity supplied that you all would be able to put into the market would go up by about 1.7 billion pounds. If you look at domestic farming labor employment, we talked about that a minute ago, over 10,000 positions created as a result of this. And if you looked at H-2A employment, you're talking about the need for another almost 6,000 positions in terms of H-2A employment. In terms of the value of vegetable production, it would increase it by about over $500 million. about $500 and some million increase in the value of vegetable production. If you look at fruit, the changes are not quite as big, but they're still pretty significant. The demand for U.S. grown fruit would go up over 400 million pounds. U.S. Fruit exports would go up some. Imports would go down by over 300 million pounds. And then prices would change a little bit on fruit. They change a little bit more than that on vegetables. If you look back, I forgot to mention that. They go down a little bit more on vegetables than on fruit. If you look at domestic farm labor employment, that's the one I was just talking about, almost 10,000 positions that would be created as a result of more vegetables being produced here in the United States. So, granted, those folks that got to keep their jobs might not make quite as much money, as they do under the current thing, but all those folks that are not employed because wages went up would now perhaps have an opportunity for employment. And, one of the things, and this goes for H-2A too, one of the things that I hear farmers telling me, they say, I have workers come to me and they're very concerned. They say, will you be able to afford to hire us next year? Will our jobs be here? I mean, they get it. They understand what's going on for the most part. And so they're concerned because they're exactly right. That is a very valid concern because if their job goes to Mexico, then they're back at a $15 a day minimum wage rather than making $16 up here an hour. So, or more than that if they're doing piece rate, for example. So that is a very valid concern on their part. The value of fruit production goes up about $272 million. So it's fairly significant to almost $18 billion total. And then once you look at these direct impacts, there are impacts on other industries as well. In other words, what are the multiplier effects of this? And so we took the results from these models of the fresh produce industry and we said, okay, how would it affect the whole economy? Well, the direct effects, which are what we've just been talking about, of both fruits and vegetables, and this is if you had both domestic and H-2A rates lower, is about $850 million. That's just the direct effect. Well, if you look at the indirect and then you take away some from the induced, which I'll explain in a minute, you get a total impact on the economy of about $1.4 billion, excuse me. And let me explain this. Direct would be the direct impacts are the impacts that we just talked about on the charts that I showed you. Those are the impacts directly to your industry, okay? Indirect would be impacts on affiliated industries, and we'll look at whose those are. Chemical companies, equipment suppliers, the local hardware store, all of those people that you buy things from, to make your farm operate. And so that indirect effect is $654 million just alone. Induced, and why is that negative? Well, induced effects are those effects that result from the workers taking their wages and spending it in the local economy. So yes, we have reduced the wage rate here. We have more workers, but in general, they do spend a little bit less in the local economies there. Now, I have to say this program that we use called M-Plan for this is a little difficult right here at this point because do your H-2A workers spend a lot of money in the local economy? Do they? They do? Okay, well, that's good because I think a lot of times they get to send most of that money back home, don't they? Yeah. Spend a good bit? Okay, well, that's good to know. Well, definitely those domestic workers spend, even if they're foreign born, they spend a lot of money here because that's where they live. Mm-hmm.
They have children here that are in the school system. They're really investing in the local economy.
Okay, that's good to know. Yeah, that's good to know, and that would make this impact a little smaller. I guess is the right word here. It would not be as negative. But that's how you come up with this program called M-Plan that comes up with these impacts. So about $1.4 billion would be the result of this in the overall economy. Here are the industries that would be most effective. No surprises here. Vegetable and melon farming and fruit farming obviously are at the top. But look at support activities for agriculture and forestry. So these are your chemical companies, your fertilizer companies, all those people that are providing inputs. You get a positive about $116 million impact there. And then it doesn't stop there. Wholesale goods, there's specifically the pesticide and other ag chemical manufacturing, nitrogen fertilizer manufacturing, and then the list goes on down the way. And it gets smaller as you go. But you can see that these other affiliated industries have big impacts as well from this. Now, if you look at just the regional effects, this is the effect on output. No surprises here. This is for vegetables, or this is for both fruit and vegetables, I'm sorry. And obviously California is the big one. And if you go down the list, then Georgia's in the top 10, North Carolina's up there about fourth, and so it has pretty substantial impacts on a lot of these states as we go forward in terms of output. This is the direct output effect. This would be employment, so the number of positions that would be created as a result of a lower wage rate. And so you see over 12,000 positions created in California in both vegetables and fruit industry. And you see it goes on down the way. North Carolina, I think we were somewhere, I don't have the numbers in my head right now, but somewhere around 1,000 or so more positions that would be created as a result of this. Georgia's a little bit smaller than that, but that's because, we're combining tobacco and fruits and vegetables in North Carolina. So, in a nutshell, what would this do? Well, it would increase consumption of fresh produce. You shouldn't overlook the fact that that's what it does, because that is what we want in general consumers to be able to do, right? Is buy more fresh produce products. It would do that through lowering the produce price, but not all those labor cost savings would flow through to consumers. Some would be captured by you, in terms of producing more product. It would decrease imports and increase exports, obviously. It would increase the quantity and the value of how much produce you all provide here in the U.S. economy. And it would provide, as we've noted, employment numbers. It would provide new positions and more jobs created as a result of this. And that's particularly true of H-2A workers. It would increase, we've already seen because of the other policy changes, such a huge increase in demand for H-2A workers. This would increase it even more. You'd have more that could come here and send that money back home. And obviously we've talked about the affiliated industries that would be impacted as well. And the biggest effects would be in states like California or those of us in the Southeast that produce fruits and vegetables. Well, when we kind of wrap this up, just some things to leave you with, and these are some of the questions that you've been talking about this morning. What awaits us coming up next year? I don't know exactly. We may see increased tariffs on Mexican products. I think the problem we have is that will probably, and we probably should view it that way, as a temporary thing, that it's going to be used more as a negotiating tool. And yes, it would, in the short term, increase demand for fruits and vegetables. But if I were a producer, I wouldn't be jumping out there to make large investments in expanding my production just because of this. If you can expand it in 1 year without buying more equipment, doing those kinds of things, yes, it provides that opportunity. But there's an awful lot of policy uncertainty as to how long that might last. Will it last a year until they negotiate something down? Will it last, 3 years till you get another administration? You don't know. So unfortunately, that's true. But in the short run, there would be some opportunities. It just wouldn't be a call for investing a lot more money. Trade wars that lead to retaliatory tariffs on agricultural exports. Well, that's always a problem. Now, it's not as much of a problem for the produce industry because you don't export as much. It's a huge issue because y'all probably also grow soybeans and corn and cotton. It's a huge issue for those kinds of crops. And that's what we saw last time. And what we saw in the last time the Trump administration was there in some of the trade wars, we saw a lot of programs that provided mitigation for farmers. And like I said, Secretary Perdue was pretty effective in getting some of those through. I can remember being in a meeting in the Council of Economic Advisors, and there was a lot of people in there that weren't really very farmer friendly, frankly. And they said, these farmers are not going to get anything. They don't need to get anything. And it was not a real good situation. But thankfully, you had a Secretary of Ag that really worked hard with Trump, and he basically told him, he said, take care of my farmers and ranchers. So I hope that's going to be the case this time. I really do. That's what we need. So what about mass deportation of undocumented workers? What is this going to look like? I don't know. I don't have a clue. Is it going to eventually get down to affect those folks that have been here 10, 20 years, who've built a life here, you know, that work on farms, and lots of them work in the construction industry? And I've got a neighbor who's probably in that category. I haven't asked explicit, but he's just bought a house and land, and he's got a thriving construction business. Is it going to impact them? I don't know. I don't know how that's going to work, but I would say this, as I mentioned earlier, I would, if something like this goes forward in one form or another, which it will in one form or another, then I think it's an opportunity to make a strong case that we've got to have some workers to replace the ones that may get displaced by this. I mean, if we don't, we're in big trouble, right? If all we have is the current H-2A program, if that's all we have to rely on. A new farm bill, yeah, we'll get one. I'm not sure what it'll look like. My guess is it'll look a lot like the last one, just with updated reference prices and those kinds of things in it. And I don't think it'll be dramatically different. I just mentioned, will farmers get payments to mitigate some of the tariff damage? Well, we'll see. I'm curious as to how this new Secretary of Ag will view this and how effective she will be with the Trump administration. As I mentioned, I think we don't want to overlook the opportunities to negotiate some change as this goes forward. We got to try. I don't know what the success will be, but it seems to me that there are some opportunities to look at this. And I guess I would end up, it's going to be an interesting year with lots of policy uncertainty, but we've been through that before, haven't we? So with that, I will stop. And if you have any questions or anything, I'll be glad to try to ask those. We are thinking about, with this model, we have the opportunity, we could modify this so that we could maybe look at and simulate what it would look like if you had an exodus of the workforce, you know, if you had some deported, or if you had substantial tariffs levied on Mexican produce, you know, what would that look like? So we may look at some of those questions too.
Any questions from the audience?
Well, I hope it'll be useful.
It is very wonderful. Amen to everything you said. It passes the common sense test in every way that advocates for us farmers. But how do we get the people you present this to, and the bureaucrats and people in government, to understand this and truly get it?
Yeah, well, that is the difficult part. I think there's two things. It depends on who you're talking to. If you're going to be talking to people within the current administration, you know, they need to understand the impact of, you know, that we're bringing in more imported produce. We're basically hurting the farm economy because you don't face the same kind of regulations that somebody in a foreign country does. I would really hit on that. And I think, though, for groups that are interested in consumers or worker welfare, this is always the one I don't get. The best thing, if you're interested in the welfare of these workers, is to make the program work, make it sustainable, and they can come here and work and send money back home. And so I think we probably need to be telling the story about these other affected groups more so than maybe even ourselves, because I hate to tell you, but I'm afraid there's not as many people that care about us anymore. But I think you need to tell the story of how this impacts consumers, how it impacts sort of the local economy in the Southeast, how it imports those workers, you know, because, man, it's a big deal to be able to come here and make this kind of money, and then you send some of it back home. I mean, it's a huge deal. And I think we need to tell more stories. I mean, I like doing the numbers, and I'm glad that they wanted me to help them with this, but we need to tell stories. You know, like workers that I hear all the time that says, I sent my money back home, my family's opened up a general store in their community, now my family has income there in Mexico where they live. That's a success story. That's a success story for everybody involved, here, there, and everything. So anyway, I think we need to tell more stories like that too. And I think we need to talk about, especially talk about the other people that are impacted, the other groups that are impacted by this. Because it's not just the farm community. It's far beyond that, as you see here.
Do you have any other ideas like that of how we get people to care about us? Because I agree with what you said.
Yeah.
It's just the unfortunate situation. A lot of people just don't care.
Yeah, I think you're right. And
we've always had the luxury of the privilege of going to the grocery store and food being there, and
Yep.
taking our families to a restaurant.
Oh, okay. Yeah, so the question was basically, how do we get people to care about us in the farm community? Well, again, I think we have to tell the story of how that impacts the local economies, because it's more than just us. We have to tell the story of how it impacts consumers. And then we need to tell the story of how these workers are impacted, because somehow there is this strange notion that farm workers have an awful life, that they don't get paid much, they work too hard. There's this perception. And if that were the case, why would they come here? I mean, they don't have to. So we need to tell the story of how this makes their lives better, not just their lives, but their families' lives better. We need to tell that story strongly, I think. So it's not an easy task. I'm not sure. I don't know exactly what our success will be, but that's exactly the way I would frame it. Yes, sir.
Do you generally think the new Trump economists would even see it favorable for the H-2A workers to send all their money back to another economy that's not ours? I would say your entire presentation, it was a great presentation, especially that table where it showed if we kept up with cost of living, 300 and something billion or million or whatever it was.
Billion. I mean, yeah.
If you just say what the government took from us is that. That's what, by doing what they're forcing us to do, that's the margin that they're taking from us.
Yeah, I mean, I think that's a good way to state it. You can say they basically took it from us and handed it to offshore producers.
Right. So
Are you more comfortable with that than us? So, yeah.
It's like now you're talking about payments. All right, now you're funding a whole bureaucratic wing to do payments. But you could have just never done that.
Well, logic doesn't always work in D.C., but, you can always try. So, but no, I think that's right. I think you have to help them understand what the unintended consequences are. Okay.
That's economics.
Mm-hmm.
Being
Yeah.
in these rooms for almost 20 years, the argument has been since 2010, how do we fix AWR? How do we freeze AWR? How do we reverse AWR? And I was much more optimistic in my 20s than I am now. I'm not seeing any movement, and I guess I am skeptical at this point that there will be any changes made. However, so we're at the point where your fifth bullet point is do you just subsidize us to continue to, I mean, I can't operate at a loss anymore. Programs like the marketing assistance program keeps me operating. So is there more of an argument, let's still fight AWR, but can we do something to help continue to assist
To
us?
mitigate what they're doing.
Because there's going to be, I'm shrinking my operation 100 acres this year. There's less bell peppers, there's less sweet, we just can't afford it. We're at $19.21 an hour in Nebraska. So, and I'm running out of customers that are willing to pay for a premium local product that's way above my competitors in Michigan and Georgia. So, is there more opportunity to advocate for payments to keep us in business until we find a more permanent solution?
Well, there will be some opportunities. I would say that what you may need to do you may need to combine your efforts with some of the folks like corn growers, soybean growers, because they're the ones, if we have tariffs, they're the ones who are going to, it's going to be detrimental to. They're going to lose their export market because they export, well, y'all know, you grow these products too. You know, they export over half their some of these products goes into the global market. So I think you have to combine your efforts with them, and you have to figure out a way to say, well, you know, the tariffs may not hurt fruit and vegetable exactly, but, you know, the other things that you're doing in this economy does hurt us. So you can, again, a lot of that's going to depend on, you know, what Trump tells his Secretary of Ag. Because like I said, Purdue was very successful in that. And I'll tell you, you know, we've tried to have legislation on immigration reform and H-2A. We've had lots of bills. That's a very, very, very difficult road to hoe just to get something like that. But I heard a law expert, I think he's from Northwest or something, but anyway, not long ago on a podcast, and he was talking about how our government nowadays is really an administrative government. And I'd really never thought about that, because these rules that all these agencies of the executive branch, the rules that they make, actually, especially now that we have trouble getting legislation done, these rules really are what really impacts industry. I mean, not just us, but everybody. And so the administrative changes is probably a more productive place to focus our efforts on right now, especially if you have some high-level administrators that are somewhat sympathetic. So I think that's where we need to focus a lot of our efforts. Yes, sir.
So this presentation was based on a reduction. Does anybody have this type of exact presentation based on the actual 31% increase that we've had instead of an 18%?
Well, we could reframe this, and it would basically be the same result.
For us to have to like talk.
Maybe that's a better way to say the question. Maybe the better way is say, what was the result of A being X percentage more? And I can't remember whether it's 31, but it's some, you know, basically in real terms it's like 20-some%, you know, over the other. So maybe we ought to reframe the question as that. That might be a better way to say it, mightn't it? That'd be easy to do, but you basically get the same results. Yes. Mm-hmm. As you lower that cost, you're also lowering the revenue side. So you might sell more, but are we net out at the same place? So, you know, what is the impact back to the farm? That's right. No. Current margins, we can't continue to operate. Right. You don't really want to produce more at the current margins, do you? Well, there is, as I've shown, there's a partial pass-through. It doesn't all pass through to consumers, but I would say, and I don't remember the exact numbers, but more of it passes through to consumers that goes in your pocket, which is not really surprising. But, you know, if you can have a positive margin and produce more product, then, you know, that's still a pretty good deal compared to what we have now, I guess. So.
All right.
Okay.
Dr. Brown, thank you very much for making the treacherous journey from North Carolina. We appreciate it. So as we're wrapping up, we just want to thank everybody for being here. I feel like some of the things that I've taken away, and yes, I'm kind of part of the system, but be a part of your own organization, whether it's the Georgia Fruit and Vegetable Growers Association or other trade associations. We are here to work for you, to work on your behalf. The more engaged you are, the more you're going to understand what's going on and potentially even have more of an impact on the things that are happening around you. We're working through this. We're going to continue to work with the Legal Foundation and Braden that we heard from. You heard his passion. He's very much on the side of the growers and very much on the side of people staying in their lanes and organizations staying in their lanes and possibly even pulling further back into their lanes. But please let us know if there's ever anything we can do as the Georgia Fruit and Vegetable Growers Association, and thank y'all for being here.